we on? Okay. Kia ora koutou. This is a resumed hearing on PC9. And before we do that, I'll just ask Muna to karakia.
Akatira, tēnā rā tātou. Morena ki a tātou I tēnei rangi. Ko te rangi tēnei, ka tā whirotia nei, I te tō tātou kingi atu heitia. I tōna rā koronei hana. Nō reira, rire hau pai mā rire. Akatira. Koutou e kanohi nei I tēnei kaupapa, no ko te huritanga o tēnei ture āwhenua, tēnei tamihi atu ki a koutou, e whakahaeretia e whiriwhiri nei I tēnei kaupapa. Nō reira, tēnei tamihi atu ki a tātou, kei noi tātou. E pai tamatua nei rā mātou e whakamuimutia, whakawhetai atu ki a koe I tēnei rā, ki a tau mai o manaakitanga katoa ki runga I tēnei, rūma I a rātou e whiriwhiri nei I tēnei kaupapa koeri nei ki te tapu orangi. Nō reire e pai tamatua, ki a tau o mōhiotanga, o māramatanga katoa, ki a whai take, ki a whai hua, ki a whai oranga, tēnei kaupapa I roto o kirikiri roa. Nō reire e pai tamatua, tēnei tā mātou nei inoi ki a koe I roto I te ngua tapu o tau, tamu I Karaiti. Āmene.
Right, kia ora, thank you, Muna, for that. And yes, it is. It's not in. Well, is it coincidental or not that we're dealing with heritage today and during this particular week? Saying to my panelists earlier today, that was a fantastic breakfast at Novotel this morning. Just about everybody who needed to be here at the Korona Hana was having breakfast, and it was really interesting. There was hardly any English to be heard around the breakfast room. It's just really nice to be here, and for those who are on the other side of that particular narrative, it's a pity that they weren't there to enjoy the breakfast. So, yeah. Right, we are here today the next couple of days to conclude the hearings on PC9. But just before we go there, I'll just ask Mary and welcome Mary. She's been an absolute rock over the last several weeks putting things together for us. I really appreciate the work that you put in, but if you wouldn't mind just doing the housekeeping for us. Thank you.
Very important, just across the hall. And in case of emergency, stairs is on the left, and don't use the lift, and follow the person on the high vest. Thank you.
Thank you. Well, as I mentioned, this is tranche 3 of PC9, and so we'll be covering built heritage and the historic heritage areas over the next couple of days, and that will be the last of the decisions that we are confidently anticipating will be out by Christmas. Watch this space in terms of the confidence on that, but that's the intention. We have just I think we have the Section 37 waivers that you've covered off, Ms. Madani, and Section 7 of, I think, your opening statement, just to confirm. So we just confirm the acceptance of those late submissions that are noted in your paragraph 7. Yeah, seems like a long time since November last year. But that's when we last convened on this particular issue. So it's been obviously a heavy year for everybody in terms of not just this particular plan change, but others. And I think we can confidently say that we're a lot closer to where we need to be than perhaps we were a year ago. So again, grateful for all the work that people have put in for that. Don't need to reintroduce the panel, I don't think, unless the panel want to reintroduce themselves. I think we're known to most observers here, so we are who we are. And we'll turn over to you, Mr. Muldowney, if you'd like.
Thank you, sir. I think probably just picking up on that last point that you raised, yes, I think where we found ourselves probably this time last year was we really did have a tiger by the tail. The plan changed the way it was formulated.
I'm not even sure we knew what beast we were talking about.
No. I mean, as I say, the plan change, the way it was formulated, meant that it was the first opportunity that stakeholders that had an interest in heritage in Hamilton City had an opportunity to actually actively participate in embedding what they saw as important within the district plan. And as a consequence of that, there was, I think, a high level of stakeholder engagement and a very significant response from some interest groups in terms of what they saw as being worthy of protection, and getting that under control and rationalised, and also getting the various experts on the same page in terms of assessment methodology proved to be the important initial steps, I think, in getting some shape or order to the plan change. And obviously that was the purpose of Hearing 2, and I think since that time there has been good success in terms of, firstly, identifying an agreed methodology for assessing heritage so that everyone's on the same page in terms of how they approach the task. We've also had good progress in terms of identifying a rational threshold at which protection should be afforded to items, potential items. And then I think the other thing that's happened is that there's been a fairly significant rationalisation of the potential items that were being promoted, both in terms of the Hamilton City notified list, but also the signalled list that had come through from the Waikato Heritage Group. So I think the sort of where we now find ourselves is in a fairly focused hearing, and I think that's probably reflected in the fact that the schedule at the moment is signalling, we're looking at probably 2 days of hearing time, and we've really got now down to I think probably about half a dozen really sort of contested issues that need to be sort of worked through in terms of grappling with assessment and where you sit in terms of, is this meeting the threshold or not. So I'm fairly confident that the panel is going to be left with a more focused task than probably what you were staring down at this time last year. So I think we've made good progress. Just very quickly, just to introduce the team, obviously on my far left we have Elise Cadigan. Elise is the Hamilton City heritage expert. She's employed by Hamilton City and has done a remarkable job in rationalising and assessing the various Built Heritage candidates over the last 12 months, and you'll hear from Elise obviously later this morning. To my immediate left we have Laura Galt, who is the expert planner, again for Hamilton City, who has been working on plan provisions in relation to both Built Heritage and some HHA matters that we'll also deal with. And then to my right, Shay Thomas, who's co-counsel for Hamilton City Council and has been doing most of the heavy lifting, I have to confess.
She's even sitting in the lead chair, I noticed.
Yes, she is, yes. So I should probably hand over to her. But I'm sure she'll nudge me if I get anything wrong. So what I've done, or we have done, is prepare opening legal submissions, and I think probably the reality with these opening legal submissions is that, as much as anything, they are a reminder of how we got here. Given the fairly significant delay between the last hearing and this, and what has occurred in the meantime, we felt it important just to recap and remind ourselves how we got here and what the live issues are. So the opening legal submissions will just work through that history. They're not particularly long, and I would like to just take you through them if I could, because I think it would be valuable. It'll probably take no longer than 20 to 30 minutes, but I think it just will set us up with a decent reminder of how we got here and what the live issues are. So with your leave, I would like to read the submissions if I may.
No, that's fine, and certainly just in terms of conversations around the panel, finding our way back and forward again, in actual fact, over this last couple of weeks has actually been quite an exercise for us to
Yes.
get our heads back into it. So
Yes.
having the signpost is very helpful.
Yep, thank you, sir. So, really just picking it up in the introduction, so the first hearing at paragraph 2, the first hearings on PC9 were back in May and June 2023, and those addressed notable trees, significant natural areas and historic heritage areas. And then the hearing reconvened in November to address built heritage, archaeological and cultural sites, HHAs and SNAs. And probably the observation I'd make there, and I think this probably became apparent to everyone involved in PC9, was it was probably 4 plan changes rolled into one. It was a bigger and broader task than I think everyone probably appreciated. So, you know, we really were knocking over 4 discrete plan changes at once, and I think that's been part of the reason that's contributed to its you know, the efforts that's been involved. Since hearing 2, the hearing panel has issued 3 decisions on PC9. The first, decision 1, dated the 27th of November, removed certain built heritage items from the notified Schedule 8A, which HCC confirmed it no longer pursued. Then there was decision 2, issued on the 8th of February 2024, which, following the release of the interim guidance relating to heritage assessment methodology, removed HHAs from Schedule 8D that were no longer pursued. And then there was decision 3, dated the 3rd of May, which contained the panel's decisions on submissions on the topics of notable trees, archaeological sites, archaeological cultural sites and SNAs. You may be interested to know that there has been very limited appeals against that decision. There are a small handful of appeals in relation to SNAs, mostly relating just to individual mapping related issues. Apart from that, the decisions have settled well and are effectively operative in the district plan. So the work of the panel in issuing those decisions is appreciated, and I think the good work is reflected in the very low number of appeals that have been received. Moving to where we now are, this reconvened hearing addresses the remaining 2 PC9 topics of built heritage and HHAs, which stand adjourned. Dealing with the procedural matters, yes, there has been an extension sought under Clause 10A, and as I indicated, the date that had been signalled in the extension request was, I think, the end of this this calendar year, or working year, I should say. I think 23rd of December or something like that. If that is immediately sounding alarm bells for the panel, and we need to seek a different proposed extension date, please let us know. And
No, we'll give you early warning of that. Yeah. In fact, you've already had it.
yes. As I say, the assumption was that everyone would want to get this completed and move on, but understand that you in particular, Mr. Chair, have a series of hearings between now and the end of the year, which may make that challenging. So in your hands on that, and we will reflect your wishes.
Yes. Well, of course, the Minister might decide to actually bring that date forward anyway. You never know.
I doubt it, but yeah. Dealing with late submissions, at paragraph 7 we deal with those parties that have filed late submissions, and at paragraph 8 we confirm that the City takes no objection to those late submissions being received. And can I just say, I think probably as a general rider here, the fact that it largely drops out of the Waikato Heritage Group submission and the various additional built heritage items that they sought that has prompted late submissions. And what I would say is that, broadly speaking, the City has no objection to any party wanting to come forward and participate in this process and say, hey, I have an interest in what's being promoted here and I want to say something. regardless of whether they have failed to comply with the statutory timeframes. So if someone was to turn up unexpected or unannounced in the next 2 days and say, I've only just learnt that something is being promoted and I have an interest in, the starting point for the city would be, it's an open door, come and actively participate. At paragraph 9, we've just very briefly touched on the legal framework, both in terms of the plan making and plan change process itself, which has been previously addressed in legal submissions, which I can take you to if necessary, but doubt it is. And really at paragraph 11, just the focus on the obligation that I think is probably at the forefront of the panel's mind, which is under section 6F of the resource management, and the requirement to recognise and protect and provide for the protection of historic heritage from inappropriate subdivision use and development as a matter of national importance. Dealing with this topic of built heritage, firstly the background. So the hearing of the built heritage topic within PC9 identifies new buildings and structures.
Sorry, just on 6F, I can't recall whether whether you've given us submissions before on I guess how to interpret 6F, given that we've got those who've argued that 6F means that anything that has any significance in actual fact, or rather not even significance, but but anything that has historic heritage should be recognised and provided for, as opposed to the threshold that we've actually determined. Have we received? I can't recall. It's not a helpful construction in the first instance because it's so broad, obviously. But
no, I think we did touch on that in one of the previous hearings, and I think I responded to the point by saying that the overarching requirements in section 6F prevail whether or not a heritage item is listed in the plan or not. I mean, clearly, in performing all functions under the Resource Management Act, you need to give effect to section 6F. So to the extent that there might be an item of historic heritage which is not listed, for example, those that don't meet a threshold that you've identified, there would still be an obligation to address the heritage element in any land use activity, for example. Now, whether you then decide that it's not listed, it hasn't met a threshold that was imposed under the district plan making process, so I'm going to give it less emphasis. That feels like a discretion that needs to be exercised in the moment by that planner or regulatory authority that's making a decision on a land use consent. So I think the point is that if there are elements of heritage which aren't captured in the proposed scheduling, that's not to say they don't still require addressing under section 6F when performing other functions.
Yeah, I mean, in the back of my mind, I'm thinking where we've got to with respect to the central police station, for example, and what you're saying is that issue will need to be canvassed in any event when presumably a demolition consent is applied for.
That's exactly right. So I mean, that's probably the best example, and we can go to it now. So and I do address this in the submissions, but that's an example where, in fact, you have two competing section 6 issues that bear upon land use activities on that site. You have the clear historic heritage elements, and then you have those cultural elements that have been identified in the evidence presented by the police. And the city's response to that was to say, in this particular instance, the appropriate response is to recognise the cultural issues and how they would prevail in a section 32 analysis of whether or not to list the site. And so for that reason it has made the decision not to list the site. The city hasn't resolved from its expert evidence which says that there are heritage values on the site. It's just that they're not being listed. So I would then expect in any proposed land use application or proposal for the site, that those heritage values would need to be in the mix in terms of any evaluation of what occurs. So there's an example of, it's not listed, but it doesn't mean that those Section 6F considerations are ignored, in any land use.
To what extent does the qualifier in Section 6F, the protection from inappropriate, to what extent is that relevant in terms of that consideration process, in terms of that threshold? So if something is ticks a number of those boxes, is the threshold of what's inappropriate higher for that item versus something that might only sort of qualify on one?
Yeah, I think potentially, yes. I think inappropriate in terms of a qualifier is very subjective, so I think it will depend upon the facts. But I think where you have a set of facts which have important cultural considerations in play, it may be that redevelopment of that site, for example, which meets those cultural considerations but also requires some degree of compromise in terms of the heritage values, could be considered appropriate. So I think there'll be judgments being made at that time.
Yeah. And when we've got these two competing Section 6 matters, what's your advice in terms of do we need to look really carefully at the wording used, given that Section 6E isn't subject to a same qualifier to only be protected from inappropriate development like Section 6F? So in the case where we've tried to reconcile them but we think there's a conflict, is there a hierarchy there that we need to give greater weight to?
I may take some time to reflect on that. I don't think it's a live issue in this plan making process, in the sense that we've taken that particular built heritage item off the table, so it's not being considered, it's not being promoted by Hamilton City now. So I haven't gone any deeper than that into what an evaluation would look like. So I can come back to you on that point, if I may. Commissioner, as I say, because it's been taken off the table, I haven't gone into that. If it was still on the table and Hamilton City was continuing to pursue it, I would have to engage with you on the Section 32 evaluation, the two competing Section 6 requirements, and why it is that I would say heritage prevails in this situation. But we're not in that space. We're not having that contest. We have reached agreement with Waikato Tainui over the way it's to be resolved, and it's not through contesting it here in this plan change process.
Thank you. I guess the resolution of the police station did give me pause for thought, given that the cultural aspects have been separated out to a separate plan change. And I just wondered, one, where is that plan change at? And two, is there potential that there could be other police station situations arising, in which case, our decision might list something, and then through that separate cultural plan change, is that where they would be reconsidered, and those values, if there was the competing values, that's the correct place for that challenge to be brought, if there is a challenge?
Well, yes and no. I think probably. So firstly, in terms of the other plan change that you're talking about, that's a plan change which was relates to sites of significance to Māori, which will have a heritage element as well, and that's, I think, still being worked through by council. So I don't know where it's at in terms of notification or where it is in the program. But if there is an item which finds its way onto this list through this plan change, which does have cultural considerations as well that haven't been raised or addressed, again, there's no reason why those considerations wouldn't be engaged in the consent, in whatever land use consenting process is then to follow. So, as an example, let's imagine there's an item that finds its way onto the list. It triggers a consent. Any proposed activity in relation to the building or the item triggers a consent. In that consenting process, there's no reason why those cultural considerations can't be brought forward and then in the mix in terms of, granting consent, and if so, under what conditions. So I think that probably comes back to that original submission I made, which is that listing these items is only one part of the process. There are resource management functions that continue through the administration of the plan, and any other parts of Section 6 will always be in the mix in terms of that consenting process, with or without an item being listed.
Thank you.
Just on that same point. I mean, in a practical sense, in a future, maybe even a near future resource consent application, would not the applicant be entitled to argue in a King Salmon sense, where you've just gone through a very fulsome plan change process and you haven't picked up all these values on my site, or the values weren't recognised? So therefore, I'm relying on that to say that they're off the table. Or do you think that would really always come down to sort of an evidential basis of what was there?
I think that's the way that you frame the question, I think, answers it. I would not say that. Well, I mean, there are important qualifiers to King Salmon, which is that if someone brings forward evidence to show that in fact the plan making process was incomplete because, for example, it didn't have evidence of important cultural issues on the table at the time of the plan making, King Salmon and RJ Davidson would say, okay, you're entitled to go back into part 2 and deal with these issues. So I think it is an evidential issue. If someone comes forward in a consenting process and says, hold on, there's some other Section 6 matters and some cultural issues, for example, which are important here, and here's the evidence of them, and this is not evidence that was considered at the time of the plan making, you would be entitled to reach back into part 2, as the Supreme Court and Court of Appeal have said. Yep. And so it's an evidence issue.
It's a pity in a way that this isn't still on the table, because it makes our decision, would have made our decision so much more interesting.
Well, we have, I think each of us observed that this is a very interesting legal point and would have probably made law, but I think the appetite for Hamilton City and Waikato Tainui making law on this point is something that I think, despite RMA nerds being excited about it, is not something that
You're not
Hamilton
characterising
City,
us in that way, I hope.
not something that Hamilton City wishes to pursue. So, yeah, it is off the table.
And just to confirm, that no one else has submitted that should be on the list.
No, and that's important, obviously, in terms of scope. That's certainly, we've had no signal that there's any other party suggesting that they would wish to pursue it and take up the issue. No. So we were at 13. So the built heritage topic, just reminding ourselves, in November 2023. It was clear from submissions that there was considerable dispute about assessment methodology and threshold, and accordingly hearing 2 was confined to the subtopics of historic heritage assessment methodology and the planning framework and plan provisions. Hamilton City also identified the notified built heritage items that it no longer pursued for inclusion in Schedule 8A, and the Hamilton City's legal submissions for Session 2 provide the background to the built heritage topic and gave an overview of the submissions received and set out the relevant statutory framework. The Built Heritage topic was adjourned following hearing 2, and there were subsequently 2 expert conferencing sessions held on the 16th and 23rd of November, and they were primarily to see if an agreed assessment methodology could be established, and there was a joint witness statement signed on the 24th of November with expert agreement on most matters. Off the back of that, on the 27th of November 2023, the panel released interim guidance in relation to the assessment methodology to be applied. The guidance revised the heritage significance criteria in Section 8 of Appendix 8 and sets the overall qualifying ranking threshold as either outstanding significance or high significance. And PC9 decision number 1 confirmed that the built heritage items that HCC no longer pursued were then removed from the notified Schedule 8A. So in light of that interim guidance, on the 13th of December, Hamilton City filed a memorandum proposing that the City reassess and recategorise the notified built heritage places in accordance with the revised criteria and threshold, and that it then identify which built heritage places it intends to pursue. And in addition, it asked that Waikato Heritage Group recategorise its 190 items that it requested be included. The panel issued direction number 21 endorsing that approach, and the City engaged the Heritage Studio along with Ms Cadogan to assist in this recategorisation process, which involved desktop review of approximately 150 places. The recategorisation exercise noted an extended place on record forms for those places that met the revised threshold, and where possible exclusions were also identified, and Ms Cadogan reviewed and approved each final recategorisation record, and Ms Cadogan has conducted site visits for all notified recategorised built heritage places that are pursued by Hamilton City. On the 1st of March, the City filed its recategorisation report confirming 55 notified built heritage items that met the threshold of high or outstanding and that it continues to pursue. Of the places no longer pursued by the City, Waikato Heritage Group indicated that it opposed 23 places being dropped. And panel direction 21 was clear that if any submitter wished to continue to pursue heritage protection for any place no longer pursued by HCC, then it must present the case to support them. Ms Callaway has confirmed that WHG is not pursuing these places further. So based on the evidence filed for hearing 3, HCC understands that no submitter is sponsoring any of the items that HCC no longer pursues. Categorisation reports were also filed by WHG in respect of 139 built heritage items, and the Callaway Family Trust confirmed support for the scheduling of the Callaway residence at 121 Maira Road. The places pursued by Waikato Heritage Group and Callaway Family Trust are discussed later in the submissions. Having largely addressed the plan provisions in hearing 2 and with the assessment methodology confirmed, this hearing in relation to the built heritage topic is primarily focused on whether the remaining notified built heritage places that Hamilton City continues to pursue and the additional items that are proposed by submitters meet the significance threshold for inclusion in Schedule 8A. So, of the recategorised notified built heritage places listed in Appendix B of the City's Memorandum of Council dated 1 March, which are pursued by Hamilton City, 4 are contested. So Appendix B of that memorandum lists the items that Hamilton City continues to pursue. And as we say, there are 4 that are contested and they are addressed in the submissions. The first is in relation to 13 Hammond Street. So this is the A. Ebbett residence, H217, and has a plan ranking of B and demonstrates high significance. The review of 13 Hammond Street concludes that the place has high historic and physical, aesthetic and architectural qualities, and Ms Cadogan concurs with this assessment. The City's recategorisation report confirms that the place has high significance with a plan ranking of B. Mr Ray and Ms Wendy Pickett, I think the owners, oppose the scheduling of the dwelling at 13 Hammond Street, citing maintenance and financial challenges. In support of their submission, the Picketts have filed expert evidence from Mr Wild which attributes medium significance to the place, and the Picketts also provide 2 desktop engineering and geotech assessments concerning structural conditions of the dwelling. Ms Cadigan disagrees with Mr Wild's heritage assessment of 13 Hammond Street. Her supplementary assessment and comparative analysis for the place demonstrates that the place is the only known residence attributed to Chitty, influenced by the Spanish mission style of architecture. There are no other known residential examples that are of similar scale or design to 13 Hammond Street within Hamilton, nor any associated with Alfred Ebbett. Ms Cadigan considers that the place is an architecturally distinctive residence and is a relatively grand local representative example of its type and style strongly associated with the time period in which it was designed and constructed. Turning to the technical assessments provided by the Picketts, appended to Ms Galt's rebuttal evidence is a memorandum from the city's building unit which confirms that the desktop assessments are of limited value in determining the true extent of works required, and Ms Cadigan and Mr Wild agree that the fabric and structural condition of a place is not a factor when assessing heritage significance.
Just on that, from a legal perspective, is it your view that those matters, the current condition, stability, etc., are not relevant factors for us to consider when we're making our decision in terms of listing?
Yes, that is the submission I make. I mean, there is, I mean, Section 32 requires a cost-benefit analysis to be undertaken in relation to, plan provisions. And so I think there's probably an argument that could be made to say that if there are exceptional costs that are associated with identifying the item as a heritage item, that those costs could be a relevant part of the overall Section 32 assessment and balancing exercise. So I think there's probably there's a way for costs to be in the mix through that means. But my submission on that point would be these costs are costs anyway that are associated with the item, whether it's heritage or not. So if there are significant costs because of the state of the building, the geotech or whatever else, those costs are embedded within the property in any event. The costs only become relevant if there's some sort of costs in addition that relate to a heritage restoration, for example, that take it beyond what you would ordinarily have to spend. And so those costs would need to be identified, and then there would need to be a judgment made as to whether the fact that those costs manifest outweighs the benefits of listing the heritage item and protecting it.
And if the onus would be on the submitter to substantiate those costs if they're arguing that they're out of the normal run of things, is that?
That's our submission. So yes, I think the point there is that, as I say, I think there are costs associated with a building and its restoration or its ongoing maintenance and improvement, which exist regardless of whether there are heritage, it's a recognised heritage item. I think the submitter would need to prove that there are costs which go beyond that, which are in the mix here, and then the submitter would need to identify those costs and say that allocating the burden of those costs to the private owner of the property should count against the heritage identification in the district plan. And I think that's the way that a submitter would need to navigate that issue.
Thank you.
We'll obviously get to this later on, but I mean, one of the things that I'm particularly interested in is the way in which that threshold is or is not crossed. I mean, it's obviously a critical threshold between being moderate or medium significance, whichever the term we use, and being high significance. There's a step change there. Obviously, Mr. Wild is saying that it falls below that threshold, and Mr. Callaghan is saying it falls above that threshold. So at some point, I'd like to have that conversation. It's probably tomorrow when Mr. and Mrs. Pickett, I think, are coming.
Well,
And I don't know if they're bringing Mr. Wild with them.
I think they are. I mean, I think that's the point, is that mercifully, I think the panel is going to be confronted with four, certainly from terms of the city's list, 4 active contests between heritage experts about where the heritage values sit on this threshold continuum of outstanding, high or medium or lower or something. So you will have to make a determination of your own as to which assessment you prefer. As I say, mercifully, I think there's only 4 occasions when you're going to be called upon to do that. The rest of it, you're going to have expert evidence, which is uncontested, which you can test yourself as a panel. But in terms of active contests, I think we have these 4. And you will be called on to pick a winner.
In that threshold debate, in your view, I noticed that some of the rankings in some of the reports, there's a high and then a qualifier like local is added. Is there, I guess I'm seeking some advice from you as to whether the threshold differs, whether it's high locally versus it's high regionally versus it's high nationally. Is greater significance attributed if it's nationally or regionally, or is high enough?
Yeah, I mean, this was one of those rabbit holes that I think needed sort of exploring and emerging from when we were talking about assessment methodology and the different methodologies, because this was part of what was starting to come through in some of the previous evidence, was this idea that there was a geographic extent of significance that changed things. I have to say I struggle with this idea. I think once something is significant from a heritage perspective, if it's significant local, well, it's significant. There will be a broader context sometimes which might have significance at a national level or a regional level, but my submission to you is I don't think the Act makes a distinction and says once something is significant and as a heritage item, if its significance is only it resonates only locally, it's still a significant heritage item. Now, again, that's my submission in relation to the way the Act deals with it. But I suspect that each of the heritage experts will have a view on this idea, and I think it's probably beneficial to hear from the experts also.
So we need to find a judicial Khaleesi virus. Is that what you're suggesting to us? In terms of the rabbit hole.
Well, that was the attempt that I think that was the purpose of hearing 2, was to try and get everyone on the same page. And I think by and large we are now on the same page in terms of assessment methodology and recognising that higher outstanding is where you need to be to make the cut here. But whether or not there's some other nuances that sit within that, like this geographic question, and how that potentially impacts the threshold, I mean, that feels like a question for the experts. But certainly I've expressed my view based on the way I say the Act deals with it, and I don't think it distinguishes it.
Yeah. Just because we're in this conversation, I don't think anyone is challenging the threshold. Are they between outstanding and high? That's not something I think we need to interrogate. So it really is only the threshold of in or out.
I think everyone accepts and has been operating, and certainly the city's approach has been to take the interim guidance that the panel issued, which says that if it's moderate or below, it's going to battle. And we've said, all right, well, we hear the signal. and so we're only pursuing highs or outstandings. Yeah, there is a what that does is it sidesteps the issue, and this comes back to the point, Mr. Chair, that you made at the outset. If something's moderate, is it still not heritage? We've sidestepped that issue, and there's not a lot of case law on this. There's not a lot of industry standards on whether or not moderate is an appropriate threshold. You'll remember that Mr. Knott, in the context of HHA, has said if something has a moderate identified heritage value, it has a heritage value, and which is what drove his original approach. The city has, based on the interim guidance, and I think being pragmatic about taking on this nuanced question, has said, let's just sidestep that. Let's just focus on highs and outstandings for now. Someone else can argue and can take the case for what we do with moderate in a heritage context. And that's been the pragmatic approach that the city has taken based on the interim guidance. So we were talking about the Hammond Street property, and I think I probably explored what I needed to there. So next is the 137 Ward Street property. This is H309, 137 Ward Street, the former Shattuck's butchery, and has a plan ranking of B demonstrating moderate significance. The review concludes that the former butchery has high historic and physical, aesthetic and architectural qualities, and Ms Cadigan concurs with the assessment, and it has been categorised as having high significance with a plan ranking of B. 6 High Street Limited opposes the scheduling of the former butchery. The submitter has not formally provided any expert evidence in support of its submission. However, appended to Ms Cadigan's supplementary evidence is a preliminary assessment of heritage value undertaken by Archifact, which was shared with Hamilton City Council in late August 2023. The Archifact assessment finds that the former butchery has high significance, but the significance is limited to the Ward Street shop front, or at most to the depth of the existing boardroom and office, and considers that it should be recorded in Schedule 8A. Ms Cadigan disagrees that the significance of the place is limited to the shop front, and her evidence is that protecting only the facade of the building, or facadism, is not considered good conservation practice and is not aligned with the place-based approach, which recognises places as an integral whole rather than separate parts. So it maintains its position in terms of supporting its inclusion.
Can I, Chair, can I have a question on that?
Oh, yeah. Oh, I'm sorry.
I just got a question on that point, the argument that it shouldn't just be the historical component, it should be the whole.
Yes.
Give me your views on the fact that our current district plan actually enables us to just protect the facade, and there are some recent examples in this city where that occurs, and how that runs contrary to the planning advice in this document.
Well, I mean, I think probably what that reflects is the existing district plan. I think you're probably talking mostly, the best example being the theatre.
The regional theatre. I'm
Yes.
also mindful of Victoria on the River, the facade, part of a couple of those buildings.
Yeah. I mean, I'm not familiar with the consenting that was undertaken in relation to those sites and the consent evaluation, but I would assume that the evaluation must have recognised that retaining the entire building beyond the facade was impossible if the broader objectives of the development were to be achieved, and it must have determined that those broader objectives outweighed the full site retention. So there must have been some judgments made about that.
In your view, and guide me here, is that earlier reference that you've had to the cost-benefit analysis, that, you know, when you look at the whole project, as long as we protect some, and if we required to protect the whole, then the project couldn't. I'm just trying to understand how we can justify in one case and not in another.
Well, I think that the point about that is that, firstly, once an item is listed, it doesn't mean that it's incapable of being the subject of development. It triggers a consent, and then the consent will evaluate the proposal in the context of the heritage values that are identified on the site. That doesn't mean that, so even if you have an entire place identified in the schedule, that's not to say that a development couldn't modify that and retain the facade and do something else. It's just that it would be the subject of an assessment. What the facadism point here, I think, is making is that in this approach, all you ever do is protect the facade, and so there's no consideration given to what happens beyond the facade. So so the distinction is, if you protect the whole place, that's not to say that that place can't be the subject of redevelopment. It can, but when you redevelop, you will be considering the heritage values associated with the whole place. And it may be, use the theatre as the example, it may be that in that situation, the consent authority says, I can't make a theatre work if I retain everything. So I'm going to retain the facade, and I'm going to allow demolition of these other elements, even though I know there is heritage associated with them. So that's what would happen if you protect the whole place, compared to this concept of facadism, which would simply say, I'm going to list the facade, but I'm not listing the rest of it. And therefore, you don't have to think about any heritage assessment if you're going to do something to the back of the building. So that's the distinction.
Thank you.
Sorry, there was one other point to make on that particular built heritage item, which is that there has been a late filing of a reasonably extensive planning report from Mr. Barrett, which we've only had, I think, 24 hours or so to review. So I do wish to just reserve the city's position in relation to a response to Mr. Barrett. There's no evidence which currently addresses what Mr. Barrett is saying. So it may be that we, well, first I think there's probably a question for the panel as to whether you are going to grant leave for this expert evidence to be filed late. You have made directions as to early exchange of expert evidence. This has come late, so I think there's probably a decision to be made as to whether you're going to accept the late evidence.
Do you want to make submissions on that?
Well, I mean, I think the point here, sir, is that the city, as we sit here right now, we're prejudiced because we haven't had any opportunity for the witnesses to consider this. I think it's probably best that you, if you are to hear the evidence, we just have the opportunity to then respond. I don't wish to take unnecessary procedural points here, but at the same time there is currently some prejudice because we just haven't had an opportunity to review it. So I think as long as we have leave to come back and address you on it, I'm inclined to just get on with it, quite frankly.
We'll talk about that in the break and let you know about that. Just to come back on the point that you were discussing with Commissioner Wilson. Yes, I mean I'm reading the as we've discussed today. I'm reading the council's position at the moment that obviously the whole plan applies to any property, and therefore what you're seeking from us is to say, well, if it has heritage values, well, that's all right. Put the blinkers on, and from this point of view, it qualifies and therefore goes on the list. But as you say, that doesn't preclude options which come forward, and of course the provisions that we'll go through later on actually make that very clear, particularly in terms of B classification.
Yes.
there's nothing in the provisions that suggests that that's an inviolate opportunity.
No.
So,
That's right.
That's how I'm reading it.
The next contest, if you want to call it that, is in relation to the Pinfold Street duplex apartments. There are 3 of them, 11 through 13, 15 through 17 and 19 through 21 of Pinfold Avenue. These have a plan ranking of B and demonstrate high significance. In the notified schedule, each flat within each duplex is separately listed. The assessment groups the duplexes as one place and confirms that the place demonstrates high physical, aesthetic and architectural and context qualities. Ms Cadigan concurs with the THS assessment. HCC's recategorisation report confirms the place as having a high significance with a plan ranking of B.
Just on that, and this is probably a question for Ms Cadigan when she appears for us, I was just interested whether the whole is greater than the sum of the parts in that case. You know, does the fact that there's 3 of them mean that there's some greater significance attributed to them, or do each of them stand and meet that threshold in their own right? So just interested in that when it comes time for Ms Cardigan's.
Yes, I think that
evidence.
feels like an expert question. I know that concept of intactness is part of a consideration. And so the idea that there is 3 that were built together and are intact and are still, functioning as a group may indeed be a consideration that form part of Ms Cadigan's assessment. So I think we'll just leave that for the expert to respond to. The Kāinga Ora submission broadly opposes the identification of new sites and buildings as built heritage, which do not meet Section 6 of the RMA. And following the filing of the HCC recategorisation report, KO filed a memorandum confirming that it opposes all of the places pursued by HCC for inclusion in Schedule HC, including the Pinfold Ave duplexes. Now, I have to say, I'm a little bit confused about exactly what the KO position now is. That there's clearly, they signal an active contest in relation to the Pinfold Street items. But there is a memorandum that was filed by Counsel for KO on the 14th of March, which identifies the opposition to the Pinfold scheduling, and then says at paragraph 5, to avoid doubt, Kāinga Ora records that it supports the removal of all built heritage items listed in Appendix A of the HCC memo. Now, I don't know whether that's an error, because Appendix A is the full list of every single built heritage item, and I don't see anything in the evidence that's been filed by KO to suggest that they're taking an active part in contesting every single item. It may in fact be an error, and the reference was in fact to Appendix C, which is the list of items that HCC is no longer pursuing, and so it supports that makes some sense, because it reads, to avoid doubt, KO records that it supports the removal of all built heritage items listed in Appendix C, which would be the items that we're intending to remove. So, as I say, we'll hear from KO on this, but it's just a little bit confusing at this stage in terms of what they're doing, because if they are indeed opposing every single built heritage item, they certainly haven't produced evidence to support that position. So I suspect it may just simply be an error. Anyway, that will, I'm sure, be clarified. Mr Brown has provided expert evidence on behalf of Kāinga Ora on the topic of HHAs, and in addressing the Wilson Street and Pinfold Avenue HHA, he also refers briefly to the inclusion of the duplexes in Schedule 8A, and says that he does not consider the recategorisation exercise and supporting documentation in Ms Cadigan's evidence providing any further information to substantiate the claim of rarity as a typology, or any other supporting information to demonstrate the architectural significance of the design, or any additional historical association that may be relevant. So there's clearly a contest between the experts here. Ms Brown's comments are rejected by Ms Cadogan. Her supplementary assessment of the Pinfold Ave duplexes provides robust additional information to support the threshold meeting the qualities of physical, aesthetic, architectural and context. Both the rarity and representativeness of the architectural style and association with early pensioner housing are demonstrated in the comprehensive comparative analysis contained within the assessment, and so HCC maintains support for the inclusion of the Pinfold Ave duplexes. And then finally there's the 65 Braid Road site, which is listed in the notified Schedule 8A as having high significance and plan ranking of B. This assessment of the place confirms that 65 Braid Road demonstrates high physical, aesthetic and architectural and context qualities. Ms Cadogan concurs with that assessment, and the recategorisation report confirms 65 Braid Road as having high significance and plan ranking of B. The Taylor Trust submitted an opposition to the scheduling of 65 Braid Road. The submission was prepared and submitted by Mr Skilton on behalf of the Trust. However, the Trust has not filed any expert evidence to support its submission. As demonstrated in Ms Cadogan's supplementary assessment of 65 Braid Road, contrary to the Trust submission, the dwelling is the only known large two-storey Hamilton example of well-known architect Terence P. Vautier's work from the 1950s, and so its inclusion is still maintained or supported by HCC. There's a couple of items that aren't supported and are no longer being pursued that originally were identified. The first is at 3 Ballock Street. So having assessed the item and undertaken a site visit, Ms Cadogan no longer supports its inclusion. She considers that the place does not represent the heritage qualities for which it was scheduled, and accordingly it's no longer being pursued. And then at paragraph 44 is the New Zealand Police Station site, and we've addressed that, and just to confirm that Hamilton City Council is no longer pursuing that item. So, as I say, of the list, the rationalised list that Hamilton City Council is supporting in terms of what was originally notified by Hamilton City Council, we're really down to the four contested items that are identified in the submission, out of a total of how many?
We started off with
What it rationalised down to? 50? 55, yeah. So I think it started off significantly more than that, but it was down, I think, Appendix B will tell us, I think we're down to about 55, and of those 55, we've got these 4 active contests. So that's the position in terms of the notified items that were promoted by Hamilton City Council. And then we move to the items that are the subject of the Waikato Heritage Group submission, which is a slightly more sort of complex situation. So the Waikato Heritage Group originally sought to include 194 additional places. And there was evidence from Ms Callaway at the second hearing, which appended 38 draft built heritage assessments. But given the focus of hearing 2 on methodology, those assessments were not addressed in any detail at that time. And Hamilton City Council's memorandum of 9 April categorised the WHG proposed built heritage places into 3 categories. First, there were the categories that the city had sufficient information on to form a view and does support them. Then there was the items that had insufficient information and therefore didn't support them. And then there were items where the city had sufficient information and does not support them. So to ensure that hearing 3 was focused and efficient, the city proposed that WHG identify a short list of priority places that it seeks to pursue that was supported by robust expert heritage analysis. And on the 26th of April this year, the WHG provided its shortlist where it identified 77 priority places that it wished to pursue. And of those, there were 34 places from the Hamilton City's Category A, which is the items that it could support. 35 from B and 8 from C. So still a fairly large amount of contested sites sitting within their 77 priority places. WHG has further refined its list of places it pursues through its evidence. Appendix 1 to Ms Callaway's evidence sets out a list of 34 places that it continues to pursue. In light of Ms Callaway's evidence, Ms Cadogan has reviewed this refined list of places and the material that has been provided in support of them. Appendix 1 to Ms Cadogan's rebuttal evidence sets out Ms Cadogan's recommendations in respect of each of them. The list of 19 WHG items that Hamilton City supports is set out in paragraph 15 of her rebuttal evidence. Ms Cadogan considers that in principle there are 2 further places, items 12 and 169, which meet the threshold for scheduling, but whose support can't be confirmed until a site visit is completed. So that means that we potentially are up to 21 of the proposed 34 that could be supported. Ms Cadogan's support of any WHG item is, however, subject to the heritage assessments being cleaned up, quote unquote, to correct inaccuracies and inconsistencies that occur throughout the WHG built heritage assessments. Ms Callaway's rebuttal evidence records that it pursues 2 items that were omitted from its list, which is items 23 and 133. Ms Cadogan subsequently reviewed these items and gives evidence that she doesn't support them. And in relation to the other items that WHG pursues, in the absence of built heritage assessments for each place, the city does not support them.
Chair, if I could, I've got a question. Help me understand, is there a plan to visit 12 and 169? I'm just...
You could give your evidence.
169, that's Marapeko Kindergarten. They denied us a site visit, so I don't think that one will be forthcoming.
Right.
And number 12 is Deanville School, and our hearings administrator contacted them 3 or more times to request the site visit, and we received no response.
Through you, Chair, in light of that, what is Council's position?
Well,
you're not supporting unless you site visit, there's no site visit, so am I to read that you're not supporting it?
That's the position. Can I just say, and I think this is again something that you can raise directly with Ms Cadogan, is that all of Ms Cadogan's site visits involve access to the site,
Right.
as opposed to observations from a public street or a public place. So I think Ms Cadogan will give you evidence of the importance in terms of heritage assessments of actually getting on to the site as opposed to just viewing from a public place. So all of the site visits that Ms Cadogan refers to that have been completed are ones where there's been access provided.
All right. Thank you for that. In terms of your point 49, again, it raises that your support is conditional on Waikato Heritage Group cleaning up and correcting inaccuracies. Is there an update? Have you been satisfied now of that? Or would you like me to ask that later as well?
I think, again, that's a matter for the witness, but my understanding is that this comment about things being cleaned up relates to assessments which have been produced in evidence to date. So whether Ms Callaway comes along in the hearing with cleaned up versions, I don't know. It would be helpful if she has. But again, that feels like a matter for the witnesses.
All right, thank you. Thanks, Chair.
And just whilst we're there, can I just ask the denial of access, was any reason given for that, or simply was a no, you can't come on site?
In the case of the Waikato Kindergarten Association, to which we requested 2 different site visits because they had 2 properties that we'd received Waikato Heritage Group assessments for, they required a police vetting type procedure that we were unable to complete within the timeframes.
Right, okay, all right. So it wasn't a blanket denial, it was just...
They didn't... Ms Wormsley has the actual correspondence. I was just advised of the denial. We weren't necessarily offered the opportunity to undertake that police vetting either. I think it was more of a, you would need to have completed this, but we also aren't really welcoming you either.
All right, we might talk about that a bit later.
So then, there's a couple of sites that warrant specific mention. One is the Claudeland substation. So Ms. Brown has provided planning evidence on behalf of Well Networks Limited, opposing the submission of WHG to include the Claudeland substation on the corner of Grey Street and Claudeland Road as a Category B built heritage item. Ms. Brown identifies that the Claudeland substation is subject to an existing designation in the district plan and states that Well intends to demolish the substation. She notes the following Part 2 matters are relevant in the consideration. Firstly, Section 7B, the efficient use and development of natural and physical resources, and Section 7BA, the efficiency and end use of energy. The expert evidence of both Ms. Callaway and Ms. Cadigan is that the substation does indeed meet the threshold for inclusion. Well has not provided any expert evidence to support its submission other than the planning evidence, and accordingly Ms. Cadigan and Ms. Callaway's expert heritage assessments of the substation are unchallenged. Ms. Galt addresses the planning issues relating to the substation in her evidence, including that the designation does not give rise to a conflict between Section 6 and 7 matters. She explains that scheduling the substation, which has been recognised by 2 heritage experts as meeting the significance threshold, ensures that Hamilton City achieves Section 6F. She notes that the scheduling does not prevent Well's ability to carry out works for which the substation is designated, nor does it prevent it from meeting its Section 7 obligations. And that's because Section 176 of the Resource Management Act provides that under Section 9.3, which relevantly provides that land may not be used in a manner that contravenes a rule in a district plan, does not apply to the public work under a designation, and the provisions of a district plan or proposed plan apply in relation to designated land only to the extent that the land is used for a purpose other than the designated purpose.
Just
The
on
point-
that point, Mr. Muldowney, thinking of demolition, is that a purpose other than the designated purpose? I mean, that's what they want to do.
Potentially, yes.
Yeah.
I think that's
So it would be caught.
yeah, it could potentially be caught. The other point I think that we make here is that, I mean, the proposition from Well is that it's futile to identify this site as a heritage site because we have a designation and we can do what we want with it. So why get in the way of that? And there are a couple of reasons why that doesn't work from a planning perspective. The first is obviously the point that you've made, which is that, hold on, it may be that demolition is outside of the purpose of the designation. But secondly, we've looked at the designation, and it's not a designation which has any detailed design, so it will require an outline plan of works. When Well Networks comes to the city with the outline plan of works, that will need to be evaluated and effectively signed off by the regulator. And that Section 176 requirement, or sorry, I think it's 176, yes, requirement, basically will say how are you mitigating adverse effects on the environment in terms of assessing the outline plan of works. Now, if heritage is identified in the plan as a particularly relevant factor, that can then be brought into that assessment of the outline plan of works. It's not to say that you would then refuse the activity and say that you couldn't undertake the designated activity, but you might impose some conditions in relation to the outline plan of works which better reflect or accommodate the heritage value. So the point there is, it's just, I just don't accept the proposition that it's of no use to list it because we have a designation. My submission would be, no, it could potentially be valuable and it meets your Section 6 requirements in terms of protection, to at least mean that when an outline plan of works is put to you for consideration, you go, that's right, there's a listed heritage item on this site, I will factor that in to how I evaluate the plan. And my submission is that that has a value. And it's not to say that WELL can't then get on with whatever it is that they're programming to do. So, and as I say, Ms Galt will give evidence on that point also.
Can I just check, just whilst we're there? So in terms of the underlying zone, I haven't actually looked at the underlying zone. Demolition isn't a permitted activity in the underlying zone? Just, I mean, just check that, will you? Because that might make a bit of a difference in terms of how we feel about it.
Thank you. Moving to items that are additional items that are pursued by other submitters, there are a few outside of Waikato Heritage Group. The first is 9 Weka Street. So Alan Callaway and the Callaway Family Trust seek the inclusion of their property at 9 Weka Street, Frankton. Its inclusion is also supported by WHG. Ms Williams has provided heritage evidence for Hearing 2 and Hearing 3 on behalf of Ms Callaway in support of his submission. In addition, Ms Laura Callaway has provided an updated heritage assessment for 9 Weka Street in her evidence. The assessment provides that the place demonstrates high significance with a plan ranking of B, and Ms Cadigan has reviewed the evidence provided in support of the scheduling of 9 Weka Street and conducted a site visit, and she concurs that it meets the threshold for inclusion as a plan ranking B. 121 Mairoa Road, the Callaway Family Trust seek the inclusion of their property at 121 Mairoa Road. A statement of evidence from heritage expert Ms Jane Matthews was provided in Hearing 2 in support of its inclusion. The evidence included a formal heritage assessment recommending that the place be scheduled as a Category B item. Ms Matthews also provided a recategorisation report in March 2024 confirming that the place meets the threshold of high with a plan ranking B under the interim guidance, and subsequently filed an updated assessment on the 22nd of July confirming her original conclusion. And Ms Cadigan has reviewed the evidence in support of 121 Mairoa Road and conducted a site visit, and she concurs that it meets the threshold for inclusion in Schedule 8A with a plan ranking of B. And then there's the properties at 21 Stanley Street and 72 Wellington Street. Jacqueline Fitzgerald and Susie Evidence made submissions seeking that their properties at 21 Stanley Street, Claudelands, and 72 Wellington Street, Hamilton East, be included in Schedule 8A. Ms Fitzgerald appeared at Hearing 2 in support of her submission. In her presentation to the panel, she spoke to the significance of her residence, of its association with notable local architect Richard William Kibblewhite, and how the place contributes to Stanley Street and the wider Claudeland area. Ms Cadigan has undertaken site visits and completed built heritage assessments for each place that have been reviewed by THS. Both places meet the threshold for scheduling as Category B places. And then finally 59 Cook Street, Diane Yates made a submission seeking inclusion of her property at 59 Cook Street, Hamilton East. Ms Yates has since formally withdrawn her submission, and accordingly the panel is not required to make any determination in respect of this property. So then moving to plan provisions, the opening submissions at Hearing 2 summarise the proposed amendments to the ODP under the PC9 built heritage topic. In her evidence at Hearing 2, Ms Galt sets out the background to the proposed built heritage provisions of PC9, describes the notified version of the built heritage provisions, and provides a comprehensive response to submissions on provisions. Ms Galt's evidence for Hearing 3 is limited to addressing the amendments that HCC proposed to the condition set appended to her Hearing 2 evidence. Notably, no evidence has been filed by any submitter in respect of built heritage plan provisions. Ms Galt's proposed amendments are minor and largely respond to matters raised in Hearing 2. In addition, Ms Galt proposes a new permitted activity rule that addresses built heritage items listed in Schedule 8A to which a certificate of compliance for demolition has been granted by HCC. In recent months, there have been approaches made to HCC by a number of submitters requesting that places proposed to be included in Schedule 8A be removed due to the fact that HCC has granted certificates of compliance for demolition of those properties. Ms Galt's evidence outlines her concern that there's no guarantee that the demolition rights will be exercised, and her reluctance to assume that, because the certificate of compliance exists, that the heritage values will inevitably be lost. In the event that the CFC is not exercised, there is value in scheduling an item that meets the significance threshold. However, she acknowledges that Schedule 8A protection of built heritage items that are to be demolished is inefficient. So, in an attempt to strike a balance between the obligation to protect historic heritage under Section 6 and avoid planning inefficiencies, Ms Galt has proposed a permitted activity rule for demolition exercised within 5 years of the grant of a CFC on or before the 22nd of July 2022.
Just on that, does that align, that 5-year period align with the elapsed date of the COC?
Yep, that was exactly the point. So the effect of the rule and associated provisions is that an item to which a CSC applies that has been assessed as meeting the threshold for scheduling is included, but upon exercise of the COC in accordance with the rule, the item is deemed removed from Schedule 8A. And so there's an updated set of plan provisions that address that.
Can I just
So-
check, can I just check in terms of that recommendation by Ms Gould, confirm that no COCs of relevance to us have been granted after the 22nd of July 22? Is it? Yeah, none have.
Yep. Okay. Yeah, I mean, there's been, as I say, the challenge here is that there are certificates that have issued, clearly with people having one eye on the potential scheduling, and the argument is that, that their argument would be, well, that should be the end of it. There's no point in protecting it. And as Ms Galt says, it's one thing to hold a certificate saying that you can demolish. It's quite another to actually embark on the demolition. And it shouldn't be simply assumed that if you have a certificate, it will be demolished and the heritage values will be lost. So this strikes what we consider to be a pretty practical middle ground, which is to say, let's schedule the item, let's recognise in the schedule that it is the subject of a certificate, and let's recognise in the activity status that demolition subject to those certificates is permitted if it's exercised within that time frame. But if not, it's a sort of a use it or lose it type right. So at the end of that 5-year period, if it's not been exercised, you're no longer going to be a permitted activity.
Does that include extended? If it was granted prior to that, but an extension is sought, is that caught, or is
It's
that
not. It's not caught by the rule. I mean, we can look at that. I mean,
I don't know whether
how nuanced we get in terms of the permitted activity rule. It may be that there's some more layers that could be added to it, but at the moment, all it's dealing with is certificates that are issued, on or before that particular date, exercised within 5 years. It's a pretty clean rule in the way that it's formulated, and it's really designed to deal with this, late rush of applications for certificate that have been made.
Just an indication of the quantum of?
I think we're looking at no more than about half a dozen, maybe something like that.
Just finally on that
we can
topic.
produce that evidence for you, actually.
So what's the effect of the deeming removal? Does that mean that the effect of that rule, that council can then just update the schedule to remove them from the schedule, or do they stay in the schedule until there's a future plan change but are just notated as being removed?
Yeah, this is where the RMA gets awfully cumbersome. We're just trying to find a practical way to make sure that we can make the change without a first schedule process. So we will have, and Ms Galt has the provisions where it makes it very clear that if the permitted activity demolition right is exercised in relation to that item, it is deemed removed. And the plan will say that. There'll be a notation that says that. Again, RMA nerds might say, I think you need a first schedule process. I'm trying to be practical about it. I don't think we need to go there.
Yeah. Well, you can always use a limited notification process at that point, and there wouldn't be anybody notified, wouldn't there?
Well, we could. I mean, there could even be an argument to say that there would be is it the section or clause 16 rights, slip rights that might be prevail as well. So I think whatever happens, I think that what everyone that's involved in this process needs to avoid is a requirement for a first schedule process, if we can, to update the schedule. No one wants to go through that.
Sorry, I'm getting detail, I know, but there's no requirement to report that, is there? If somebody, in actual fact, what's the sort of mechanism for demonstrating that the demolition has taken place? There's no. Is there any requirement? There? I mean, you wouldn't know, would you? To just go silent.
That's true. I don't know. Would it be reported through the building team of a council? I'm not sure if a demolition. Does it matter? Probably not. I mean, it starts to become a bit academic. I mean, anyone who then wants to pick up the point, as soon as they go to the site, they'll realise there are no heritage values. We're dealing with a remnant. But it may be that there are some notations that could be included within the district plan which could help with this. As I say, the rule has been drafted in its present form as a fairly lean, clean rule, but if there are some further notes or advisory sections or something that could be embedded to give people a bit of guidance on this, those could easily be added. So that really gets to the conclusion of the built heritage topic. So HCC pursues 52 notified recategorisation or recategorised places for inclusion, which have been assessed as meeting the significance threshold that was established by the panel in the interim guidance. 4 of the 52 items are actively contested, and the city recommends that these places be retained for the reasons outlined in the evidence of Ms Cadogan and Ms Galt. In addition, HCC supports the inclusion of 121 Mairoa Road, 21 Stanley Street, 72 Wellington Street in Schedule 8A for the reasons given by Ms Cadogan. And HCC supports the 19 Waikato Heritage Group items, which is provisional support until the assessments are quote-unquote cleaned up to correct any editorial inconsistencies and inaccuracies. And the city recommends that the panel approve the updated plan provisions as presented by Ms Galt. So that then completes the built heritage items topic, and then it's just back to resolving the sort of the remnants of the historic heritage areas topic, and this is a fairly tight and confined issue. We've got the background to the HHA areas set out in sections 74 and 75 and 76. I probably don't need to go through that. I think probably at 77, if we just pick it up, we're following hearing 2, the panel released its interim guidance in relation to heritage assessment methodology, indicating the assessment of medium or moderate significance was unlikely to be accepted as the appropriate threshold for scheduling. So that was that sort of watershed moment where the city took that guidance, and in reliance on that indication, HCC subsequently gave formal notice that it no longer sought to include 9 HHAs that it had assessed as having moderate significance. So it took it off the table, so to speak. And on the 8th of February, the panel released PC9 Decision 2, which confirmed the removal of the 9 HHAs no longer pursued. In addition to these 9 HHAs, Ms Galt stated in her supplementary evidence the following 4 HHAs that were included in the notified schedule, but for the reasons stated by Mr Knott in his primary evidence in hearing 1, were no longer pursued, and that was Oxford Street West, Anglesey Street, Marama Street and Jamison Street. So that leaves 20 remaining HHAs, and the city's memorandum dated 9 April confirms that it continues to promote those remaining 20 that are identified in Mr Knott's supplementary evidence as being either outstanding or high significance, and that's based on the revised assessments that were assessment methodology. And at 80 I've set out the outstanding and high HHAs that are continued to be pursued. So as recorded in the memorandum dated the 9th of April, the City considered that the hearing of evidence on the HHA topics was completed in November 2023 and the panel could issue its decision. The City noted in the memorandum that there was an outstanding matter as to the final set of draft plan provisions, which were at that time being fine-tuned to ensure consistency across the heritage areas and items, with some minor edits being made to individual area statements. And there was directions allowing the submitters to comment on any final draft provisions. And then on the 7th of May, Kāinga Ora sought a limited opportunity to provide comment on HHAs as part of Hearing 3 to identify spatial refinements and assess a number of the contested HHAs utilising the updated methodology. And the panel granted the request, allowing for the exchange of evidence. And then, in addition, there was Mr Baker, who made a submission seeking the inclusion of a new Fairview Downs HHA, and he also sought the opportunity in this hearing to file further evidence, and that was granted. So, in terms of this hearing, HCC continues to pursue the remaining 20 HHAs, and it relies on the extensive evidence which has previously been provided, which is set out at paragraph 84, which you can see there. In terms of the Fairview Downs HHA, Ms Callaway has provided further evidence on behalf of Mr Baker in support of his submission proposing the inclusion of the new Fairview Downs HHA. Ms Callaway reassesses the proposed Fairview Downs HHA in accordance with the interim guidance and concludes that it meets the threshold. And as recorded in Ms Galt's supplementary evidence, the City relies on Mr Knott's evidence and assessment, which concludes that Fairview Downs had a low heritage significance and therefore did not meet the threshold for scheduling. So it's not recommended by HCC for inclusion. In terms of Kāinga Ora, Mr Brown has provided further expert evidence on behalf of Kāinga Ora addressing HHAs, and in addition to that submitted in the previous hearings, the City's position is that Mr Knott has provided comprehensive evidence and rebuttal of that evidence, and that there's nothing more required from Mr Knott. And I'll just make submissions on Mr Brown's evidence once it's at the conclusion. In terms of the plan provisions, on the 3rd of May, the City circulated draft plan provisions on the HHA topic. There was feedback received, and in response to that feedback, Ms Galt proposed additional amendments to the provisions which are explained in her supplementary evidence. She also made amendments to the HHA statements to include clearer maps and make corrections to typographic and grammatical errors and improve clarity in referencing. And those updated statements are appended to her evidence dated the 3rd of July. Christina McKelman has provided a lay statement on behalf of the Frankton East Residents Group, which confirms its support for the Frankton East HHA. In addition, FERG seek minor amendments to the Frankton East HHA statement, which, having conferred with Mr Knott regarding this request, Ms Galt now supports. So those amendments can be picked up on behalf of FERG. And then notably, no other lay or expert evidence has been filed in relation to this hearing addressing the HHAs. So the conclusion on the HHA topic is that the City continues to pursue the 20 remaining HHAs and seeks the panel's approval of those and the updated plan provisions provided by Ms Gold. In terms of the evidence that you'll hear from the City in this hearing, the first witness you'll hear from is Ms Cadigan, who will present the expert evidence, heritage expert evidence in relation to the built heritage topic, and then we'll hear from Ms Galt, who will present the planning evidence which supports both the built heritage topic and the HHA topic. So that completes the opening legal submissions for the City. Happy to address any other remaining questions, or we can get straight to the evidence.
Thank you, Mr Muldowney. Just one general query. Tomorrow we have a Miss Patricia Osborne coming with some request about the inclusion or otherwise of the Enduring Architecture Awards. And I can't recall what the response from staff was on that particular issue. Just before we hear from her, it would be useful to know what that submission supported a number of architects who were advocating for that properties that had received the Enduring Architecture Award be listed, but I can't recall what that was all about.
In my
so-
recollection, I'll defer to the team here, but my recollection was that the primary submission which sought that recognition was not pursued. And so I feel as if Ms Osborne maybe whether she's attempting to now or you know to now pick up and sponsor this herself or simply support the original submission, I'm not sure. But
It's a bit difficult, isn't it? She's a further submitter, isn't she? So
yeah,
that's
she is a
hard.
first submitter.
Yeah.
Primary submitter largely fell out of the process after Direction 21, where they didn't produce a report or any assessments.
Yeah, that was my recollection. So I think the primary submitter that this submission supports has dropped out of the process and is no longer actively pursuing and isn't producing any evidence to pursue the original submission. So I think Ms Osborne and will probably need to confront the fact that there's no body of evidence
Yeah.
that she has to support.
I wonder whether somebody maybe should make that point to her rather than waste her time and potentially ours as well.
I believe it has been made to her. Yeah,
Correspondence.
but she still wanted to attend.
I think we're done for the moment.
Thank
so,
you.
We might take a break until 11 o'clock in that case. Or,
Thanks, sir, and then we'll hear.
thank you. All right, thank you. Let's let's resume. That was a very nice catch-up over tea. Not a great deal to do with this particular issue, but it was good to catch up again. So, all right, we're with you again now.
Thank you. I'll hand over to Ms. Cadigan. She's prepared evidence in chief and also evidence in rebuttal, and I think she has an executive summary. So, sort of in your hands as to how you want to proceed. I'm assuming all evidence has been read. So I think what I'll just ask Ms. Cadigan to do is just deal with her executive summary and any update from her rebuttal, and then just simply take questions, if that's okay.
Yep, that'll be fine.
Thanks, Sue. Over to you.
Thank you. I was just going to read the conclusion of my rebuttal statement because we've moved on slightly from some
You
of
might
the-
need to just focus on your microphone a little bit more. Thank you. Yeah.
I was going to read the key points from my conclusion of my rebuttal evidence because we've moved on somewhat from some of the executive summary matters in my primary evidence. So we've got that I support 19 Waikato Heritage Group proposed built heritage places for inclusion on Schedule 8A of Council's Operative District Plan, and I refer to Appendices 1 and 2 for my recommendation on each place's plan rank, threshold meeting qualities, extent of place and exclusions. And on that I do have an updated set of Appendix 1 and 2 dated Monday after I received the updated Waikato Heritage Group assessment for the railway station and in response to Ms. Callaway's rebuttal evidence. So we can distribute those. I support the inclusion of the Callaway residence at 121 Mairoa Road on Schedule 8A of Council's ODP as a Category B built heritage place. I disagree with Mr. Wild's attribution of medium significance for 13 Hammond Street, and I maintain that the notified built heritage place has high historic and physical aesthetic architectural qualities. And I disagree with Mr. Brown's statements regarding Council's level of evidence for 11 to 21 Pinfold Avenue, and maintain that the notified built heritage place has high physical, aesthetic, architectural and context qualities. And that concludes my rebuttal conclusion, so happy for questions.
Is that all you want to say at this point?
At this point,
Okay,
yeah.
all right. Dave, do you want to take up?
Yes, thank you, Ms. Cadigan. Good morning. I've just got a couple of questions which focus on Mr. Brown's criticism of the, well, it's really both Built Heritage and the HHAs in Wilson Pinfold, that when you read what he wrote, he has a bit of a go at both aspects. I'm not quite sure of where he was headed on that, but nevertheless, if we go down to I think it's paragraph 37 of your rebuttal.
Mm-hmm.
I just wanted to understand a bit more about the comparative analysis that was undertaken for this HHA. And I note that the joint witness statement recognises the importance of all the thematic analysis that you've been doing, but also the experts agreed about comparative analysis being quite important. Mm-hmm. And I note that we've got information on the various forms of state housing that had been built in the city, and clearly the houses at 11 to 21 Pinfold form part of that, one of those typologies. I'm interested in sort of how the comparative analysis of different areas of state housing enabled you to, I guess, select some of those areas for for being high and therefore being included, and perhaps other areas didn't get included. I mean,
Can I just?
was it the case that you've looked at all those different typologies and we've ended up with the best examples?
Is this a question on historic heritage
Yes,
areas?
it is, not on built
I'm
heritage.
not council's expert for historic heritage areas, just the built
That's right, you did
heritage
say
places.
that, yeah.
So I'd have to defer to either Mr Muldowney or Mr Knott on that. My evidence is just for the pinfold duplexes as a discrete built heritage place.
Yes, okay. Well, just on that then, so those examples, which are both built heritage and part of the HHA, they are I guess the best examples that we have in the city of that type of design.
Yes, to my knowledge, they are the only examples within Hamilton City
Right.
of that type of design.
Okay. Right. Just down at 39, and this is more on built heritage. Actually, no, down at 41, you say, in my opinion, 10 to 12, and this is on Watts Crescent, 10 to 12 and 15 to 17 Watts Crescent are typical examples of the late 40s single-storey duplexes, commonly found in areas of state housing. And they rate sorry, I'm getting a bit confused between the two here. In terms of 11 to 20, going back to 11 to 21 pinfold, I note that you've got them rated as high, and therefore they'd be some of the best examples of the state housing in that area, in that particular HHA. Anyway, I know you're not going to comment on the HHA, but I mean that'd be the pick of the bunch.
They are different to what is generally found in that HHA. So that HHA, to my knowledge, is a late 1940s development, the Pinfield Watts area. There were 4 sections that were left empty for a number of years.
Right.
And then there were originally 8, we've lost 2, so there's 6 remaining duplexes that were subsequently constructed on those vacant sites. So they represent both a different typology of state housing in terms that they're pensioner housing, 1-bedroom flats, duplexes for pensioner housing, but also that they represent a different architectural style, which is quite a shift from your 1940s typology, shifting into your more modern early 1950s typology. And so those 3 that are left now stand out as a coherent group. They are the only known examples of that type of state housing in Hamilton.
With the monopitch roof. Okay. I guess their rating of high, and when I read some of the comments from White and Durrell, and I know I'm straying back into HHAs here, but it's a bit hard to distinguish the two here. The White and Durrell comment was, the rest of the descriptions of the architecture, etc. qualities describes both the state and non-state houses as largely being typical, suggesting that were it not for the pinfold duplexes, the HHA would be ranked as moderate at most. So, I mean, we've got these houses here that are high, but I'm left wondering about how that's actually sort of dragged the whole area up. But for them, it might not have actually made that high categorisation as an HHA.
Right, again, I wouldn't like to comment on the values of the HHA, simply just the duplexes as a built heritage place. I'm not as familiar with the Dorrell and White, did you say?
No.
Submission or evidence, as it's not part of the built heritage topic.
Right.
So I couldn't say, sorry.
Moving location to Hammond Street. And at your paragraph 35, again of your rebuttal. So you say they refer to the supplementary assessment and comparative analysis for 13 Hammond Street demonstrates that the place is the only known residence attributed to Chitty, influenced by the Spanish mission style of architecture. In relation to Mr. Chitty's work, there's other of his work that is scheduled.
Yes, so if we refer to the Appendix 1, which is the comparative analysis within the supplementary assessment, there are two, I've broken it into two separate analyses, one of which looks at 13 Hammond Street in relation to known Chitty places,
Yes.
some of which are scheduled, some of which are not. And then the second set of analysis is known Spanish mission style influenced residences within Hamilton.
Right,
So that we can see it from both of those
okay.
perspectives.
And most of Mr. Chitty's work was of what nature? Was it residential or commercial?
A combination of
Combination,
both.
right. And this is his only known residence attributed to him, which is influenced by the Spanish mission style. I just sort of wondered whether, I mean, it's a bit like saying, here's a landscape painter and here's the one thing they did that was abstract. And we'll make that special because they're a good landscape painter. I mean, is it because it's Spanish mission style? I mean, does that sort of elevate the importance of it as a piece of his work, given that he's not known for that?
What it does is it places his work in a wider continuum or context of what we understand about how he practiced. So this particular building is one of the last commissions that we know he undertook. And so if we look at guiding documents such as the Auckland Council methodology for assessing historic heritage, some of the inclusion indicators that you take on board when assessing a place for built heritage sort of indicate to you that does this particular building give you a better understanding or a clearer understanding, or is it the only known example that enhances our understanding of this particular architect's repertoire of work? And so that's where I can place this particular residence and say we've got one commercial example where there's a similar level of Spanish mission influence in the place, and that's currently scheduled in the district plan, and that's in the comparative analysis. And so we can say, well, looking at our comparative analysis, Chitty largely worked with an arts and crafts basis earlier on. So he was sort of working 1910s, 1920s. We could say, well, this particular property then shows us that towards the end of his career, he was picking up on those architectural cues that were coming through internationally. He started using this architectural influence in his design, and this residential example is the only known example that we've got of that shows us how he was interpreting that in a New Zealand vernacular.
Right.
So that's how the comparative analysis works alongside that attribution of significance under that criteria.
Right. Okay. Thank you. That's all for me.
Yes, thank you. So just to revisit the questions that I posed to Council, so just taking you back to Pinfold Ave and those three duplexes, and my question was, are they, is the significance of the sum total of them all greater than any one of the parts? Could you comment on that?
Yes, in this case, because we see them as as a separate or discrete development within a wider state housing area. I think the value does largely come from them as a group. That's not to say that should we assess one individually or even two together that they may or may not meet the threshold for scheduling, but they're definitely enhanced and have, in my opinion, greater significance when considered as the three adjacent places.
So just to be clear, you've assessed them as a group, but you haven't individually assessed them as if they were on their own, they would meet the threshold. It's as the group that's been...
It's as a group, yes.
Okay. And then just in terms of, I think one of the qualities is about the rarity, the fact that there's three of them, in your view, that still meets that criteria of rarity,
Yes.
given that says three. Okay. And then the second question I put to Council was around the threshold, and in some of the assessments that have come forward, there's the reference to high local, high regional, high national. What's your view? Is there a difference, or is it simply as once you trigger high, if it's local, that's enough? Is there a difference in importance between those?
My opinion is that high local is your threshold, and so that is enough to be considered as built heritage or historic heritage. Local, regional, national, or the geographic factor that we split out during our conferencing, it's useful for contextualising places, and it's helpful for undertaking exercises like comparative analysis, because it helps us to place the item, building, structure, whichever, and to say, well, these are the only ones that or the only one that we know about within Hamilton, or it's the only one we know in the Waikato or in New Zealand. In the absence of a Hamilton City methodology specific to, say, the interim guidance or what came out of conferencing, there's no real guidance on whether or not that changes the threshold. In my experience at using the Auckland Council methodology, once you start getting a place that's met the threshold of high beyond, and the significance can be demonstrated largely via comparative analysis to be beyond the locality or beyond the region. That's when you start looking at it and going, well, this is probably a place that's demonstrated to be of national significance, and that's usually your indicator that it's probably of outstanding value.
Yeah, so it links into that greater threshold.
Yeah.
Kapai.
Yeah.
Right. And then just finally, one question in relation to the 13 Hammond Street. It's sort of noted in the assessments that it's associated with Alfred Ebbett. And I just wondered, obviously he's associated with, cars and that sort of thing, but this is a personal residence. It's not a place that he worked or was, associated with that well-known aspect of him. Is that a relevant consideration for us in terms of, does it meet that criteria? Would it be more significant if it was his workplace rather than his home?
I don't necessarily think so. No, I think it's common practice, and again, I would refer to the Auckland Council methodology because that's one of the leading documents that heritage experts have to rely upon when assessing. And it's a person of significance, and can we make that connection for them to be notable or significant at geographic level at a place? And so Mr. Ebbett, and I think I've said it in my rebuttal, in my view, it's appropriate to attribute that significance to him as a local, notable individual person in Hamilton, to that founding of the business that then weathered so many adverse worldwide situations, I suppose. And that, yes, there's no other remaining buildings associated with him or his business. It may be a factor to say, well, he built this new premises and that's a reflection of the business expansion. We don't have that to be able to say that. But I think regardless, a residence is an appropriate place to attribute that significance to him, both as a person and as a businessman.
And does the length of stay at a particular place factor into that? So I think in this case it was 20 odd years or something, wasn't it? Or
Yes. And again, I will refer back to the methodology that guides us in how to make these assessments. And one of the inclusion indicators of significance is, did that person reside at that place during that period of significance? And in our case, the answer is yes, most definitely. And we've got, it's not in my evidence, but I noticed Mr. Wild had included a number of photographs from the National Library, which to me also goes some way to demonstrating that that significance was there. We've got a national aviation company well known for documenting our landscape, who came and took these photographs of Mr. Ebbett at his home with his children. They also visited the business, well, it was because it was extant at that time, but I think that goes some way to demonstrating the significance of him and the relationship with the house.
ngā mihi.
Thank you, Chair. Ms. Callaghan, just in your evidence, you are supportive, you make your support conditional of the Waikato Heritage Group on the basis that they correct some inaccuracies, clean it up, I think is referred to. Are you satisfied that that's now occurred? Have you seen a accurate summary that would meet your support criteria?
I have not seen any updated assessments yet, but we were advised by Ms. Callaway on behalf of the Waikato Heritage Group during the break that they are imminently forthcoming.
Right.
So I would reserve my comment on that until I've seen the documents.
Excellent. So we'll have an opportunity to ask you for your opinion later once you are either comforted or not.
I would say so, yes. I am yet to see anything, and then I would need to take some time to review them. So I would need a sufficient time frame to give you that answer.
Okay, thank you. If I can now turn your mind to 137 Ward Street. In your rebuttal evidence, you disagree with the significance or the limitation that Artefact assesses that really 137, it's the facade or back to the existing boardroom and office. You believe that it's best practice that you need to align with the place-based approach, which recognises places as an integral whole rather than in separate parts. Talk to me why you believe that is the case, and explain to me why you feel there could be the inconsistency that we have in play with our operative district plan, where in fact council under its operative district plan permits certainly facades to be kept, but not the whole. I need you to lead me through that.
Okay. I would refer to Mr. Muldowney's discussion on this earlier, in that I also am unfamiliar with the Waikato Theatre development, so I couldn't say, I do not know whether or not it was just a facade that was scheduled in the first instance or whether it was the whole building, nor can I speak to the resource consent process and the assessments that were undertaken and the conclusions that were drawn. I would also defer to Ms. Galt, because I'm not sure that our operative district plan does only protect facades. From my knowledge, the whole site is identified in the district plan under the legal description. It doesn't go to the extent of identifying exclusions, which is something we've recommended be brought in through this plan change. And so I would assume that the consent process you're speaking to did consider the building in its entirety, as Mr Moldani talked
Okay,
you
so
through.
thank you. Could you expand on why you believe, let me rephrase, are there elements of the building at 137 beyond the boardroom and the office that you believe is historically significant, as opposed to, well, I'm including the first half, I better include the whole?
Oh, sure, yes. So I will just find the relevant paragraph to take you to in my evidence.
Is this your evidence, primary evidence, or your rebuttal?
Primary evidence. We didn't receive anything from the submitter, so there's nothing in my rebuttal about
Okay.
137 Ward Street.
Oh, I'm sorry. Mr. Madali refers to your rebuttal evidence dated the 9th of August, paragraph 61.
Okay.
So I just had assumed you must have said something.
I don't have a paragraph 61 of my rebuttal.
Oh, I might have been, sorry, that could be a reference to the supplementary statement dated the 3 July.
Okay.
At paragraph 61, it begins, I disagree with Archifact's
Oh,
limitation
yes,
of
that's my
significance.
primary evidence.
Okay,
Yep.
I'm sorry. I just,
Supplementary statement dated 3rd of July, sorry.
no problem. I had misread. Well, okay,
We're on the same page?
we are.
Yeah?
Thank you.
Oh, yes. So, what we've got is if we start at the recategorisation exercise, we've got the Heritage Studio and Ms O'Neill doing a desktop review of our notified built heritage places. And it was primarily during that exercise that the full extent of the site and the two buildings they're joined, but you can read them as two because it's got a through site between Ward Street and Nisbet Street. So the Nisbet Street end has more of a story and a half type sort of height, I suppose you would say, as opposed to the single story on the Ward Street side because of the topography. That when we went through the WSP report and revisited the evidence that they had relied on to make their calls, the statements in their assessment, that there was an opportunity to emphasise the fact that this particular development by Mr Shattuck was the sort of height of his business success, and that this was the only Central City site that was both a retail operation, a processing operation, and a sort of an operational delivery fleet operation. And so picking up on all of those aspects of the history of the place, it was proposed to not only continue through and for council to pursue that as a built heritage item, but to really strongly acknowledge that this went beyond just a simple facade or butcher's frontage of a building. It represented a lot more than that as this purpose-built whole system for the business. And so that's why we've put forward the extent of place. The extent of place is the same, it's still the legal description of that site, but to really recognise that all of the buildings on the site contribute to that historic significance and understanding of the place as it was developed and constructed and how it operated, as opposed to simply recognising that it was a nice, aesthetically pleasing shop frontage.
Okay. Thank you. My final question, if I could, turning now to Hammond Street.
Yes.
I'd be interested, I see that you put forward an argument for the design, the Spanish design, you referred to the windows. How important is the tiles, you know, the tiles that make up the roof
The roof tiles.
on Hammond Street in regards to its built heritage status? And the reason for the question is the technical reports, albeit desktop, have suggested that it's very heavy and it's creating some issues. So is that, is the roof a critical component of you deeming it to be historically relevant? If that
It
makes
is
sense.
an element, an important element of the overall physical aspect. Is it architectural, aesthetic, physical is the quality that we've attributed high significance to. The roof tiles represent both the Spanish Mission and the English cottage or arts and crafts style period of development that the house was constructed within. So they are an important part of the building.
Okay, thank you.
Thank you, Ms. Cadigan. My question might seem rather strange, but it has struck me, I guess, throughout this dialogue on the heritage things, that each of the heritage experts who we've had before us come from very different disciplinary bases. I mean, yours is anthrohistory. Richard Knott's planning urban design. Adam Wilde is architecture. Brown is archaeology. And I wonder to what extent that actually influences the way in which you approach what I see to be the most difficult of the criterion, which is criterion B, which is the physical, aesthetic, architectural qualities, dimension, which seems to be a basis upon which most of you, I agree or disagree. That seems to be the crunch one as far as my reading goes. And it may well be that that's actually quite a portmanteau in terms of it's got more elements in it than it probably needs, but that's the one we're dealing with. But I wonder to what extent that actually underpins the differences of the allocation or the attribution of significance to that. Because, as we know, you only need to score one on these ones to get above the line, basically, and that's the one that seems to me to be the one that actually scores most regularly above the line. So it's a general question in terms of the way in which heritage experts are developing and approaching matters. Have you got some sort of reflection on that? I mean, I saw the same thing with landscape architects 15 years ago. I've seen the same thing with archaeologists over the same period of time. And clearly there is a lens that you bring with you at that point in terms of making that assumption. So your reflection on that?
I would say that highlights the importance of having a guiding document. So no matter what related but different discipline that you might come from, where you've got a standardised or an accepted or an agreed set of criteria, thresholds, and assessment indicators, so like a methodology document that you can then use to rely on, you're always going to bring a different lens to the place. I think it's also important to understand the basis of fact or research that goes into sort of cementing where your opinion or your professional opinion is coming from and the advice that you're giving. I've noticed that some of the critiques or the evidence coming through, especially on that architectural aesthetic, which is the next one, physical attributes type criteria, doesn't necessarily offer an alternative to what I've suggested. It merely just sort of suggests that there might be a different way of considering it, but the evidence that I've put forward isn't actually challenged in that sense. I haven't seen anyone come in and say, well, I also went and picked up XYZ plans and XYZ building permits and things like that to actually drill down into the research that supports these conclusions.
But in terms of that criterion, when you were engaged in the expert conferencing on that one, I mean, was there discussion as to unpacking that particular one? Because the dimensions are not obviously, they don't necessarily align, obviously. And I just wonder whether that was a, if you like, that was a compromise criterion that everybody could agree with just by building it up the way it has been built up in terms of physical aesthetics and architectural qualities?
I don't recall there being any particular discussion beyond we had a conversation around keeping it as sort of 2 sentences or in a paragraph type format as opposed to breaking it down and having that overarching sentence with the bullet points underneath. And I think the consensus was that given that that criteria picks up 3, you know, you've got the 3 different parts of it, that was the clearest way to understand what was being asked of you in assessing that criteria.
And I mean, my perception might be incorrect, but do you agree or not that that is actually quite that's a critical tipping point criterion?
I think it allows for the different perspectives to come into play because there are a number of, not tipping points, but you have to put forward, you have to demonstrate notability, or if I bring it up actually, the way it's written. You've got a number of qualifiers, I suppose I would say. Yeah, notable or representative examples. So even you can break that first sentence into 2. You've got notable and representative. In my view, representative, you largely have to demonstrate through a comparative analysis, which is what came out of the conferencing as well. But then...
Sorry, just in terms of where you disagree with others, is that on the basis that you, and I'll go and have a look at that later on, that the others have not provided those 3 heads, you know, argument sufficiently with those 3 heads, or I've tended to emphasise one rather than the other, or how do you see that difference? And I guess we're really only talking about the 4 that are, you know, the 4 B ranked ones that are in dispute.
Yes, and I've only seen expert evidence on 3 of those. We haven't seen anything for Braid Road on that.
Right.
And 137 Ward Street, I believe we've got agreement from Archifact that it does meet that criterion. So it leaves Hammond Street and the Pinfold duplexes, which both have this quality. I don't think that Mr. Brown has demonstrated that the duplexes are not representative examples. I think that my analysis, especially the comparative analysis, does demonstrate that on both of the 2 tables that I put forward to support that conclusion. And Hammond Street, again, I note Mr. Wild he doubts the connection with Chitty. But I don't think that his evidence necessarily contradicts that the place is not a distinctive example of its type, notwithstanding the connection with Chitty, which is why I've got both sets of comparative analysis tables in the supplementary assessment.
So, and I guess I'm just asking you for an opinion on this one. In terms of when we have to come to the making a call on, particularly on those 4, is it your view then that we should actually somewhat laboriously go through the criteria and make sure that in actual fact those have been ticked off by those who are in dispute? Is that the way that we should approach our determination and in terms of the differences between you?
I'm not sure that you will have both in front of you. I think
well, that's the question. That's the next question. Is if that's the proper way of going about determining who we believe, if you like, or who we prefer. If it's not to apply the criteria quite deliberately, what other option do we have?
I would ask that you take the evidence in front of you and see which expert has made the strongest case for meeting that criteria. In which case, at this point in time, I believe my evidence is the only
Well, that's
example
unsurprising,
of that.
isn't it? I'm not inviting you to... Yes.
Can I just jump in there? Just a query with the 137 Ward Street, I think you referred to the Archfact assessment, is that
Yep.
the right? Now, that was done before the methodology was
That's right.
changed, wasn't it? So
Yep.
we don't have an updated assessment against the new methodology, and the methodology changed quite a bit. So there is at least the potential that the outcome might be different from your understanding?
Yes, they sent that directly to council just at the close of the last set of evidence dates. And my understanding for that place is that the ownership has changed. And so the late submitter, which is the new owner, was it yesterday, I believe, we received some planning evidence, but they've perhaps chosen not to pursue their contest with expert evidence.
Okay, just come back to the question. I mean, it seems to me that the only way that we can actually determine a preference between the experts is to apply the criteria that should have been applied in the first instance or in the latest instance. And yes, in the absence of some of that, we might have a problem, but I guess we'll have to work that one through. Dave, any other questions? Anything else? All right, thank you, Ms. Callaghan. Thank you.
So, as I said, we will just, if I can reserve leave to recall Ms Callaghan if we need to at any stage, obviously to answer any questions that come out of Mr Wilson's issue with the clean-up of the WHG. We'll need to come back on that. Plus, we do need to potentially come back on this planning evidence that's been presented late. So, with that reservation, I'll hand over to Ms Galt, who is the planning witness for Hamilton City Council. Ms Galt, like Ms Callaghan, has produced a number of statements of evidence. There's planning evidence on HHAs dated the 3rd of July. There's supplementary planning evidence on built heritage dated the 3rd of July. And there's also I think it was an earlier one as well, wasn't there?
Yes.
9th of August is a supplementary as well. So I'll just ask Ms Galt to, if you can, just sort of summarise your evidence on the basis of those previous statements in terms of where you're at today.
Thank you. And which one, are you going to hit HHAs or BHs first?
I will start with built heritage.
Okay, thank you.
Albeit what's discussed, but I think that's a slimmer of the two. So my built heritage supplementary evidence was filed earlier, and I was going to take that as read. The changes we have, the changes that I have recommended in that are fairly benign, the corrections to what I had put forward in November.
You might think they're benign, others might not.
In terms of the rebuttal on the built heritage, again, I'll take the my paragraphs 5 through to 9 on the Central Police Station as read, given that there's no further contest on that. Moving to Well Networks and the Claudelands substation, are you happy for me to read through that? Ms Sarah Brown has provided planning evidence on behalf of Well Networks Limited in support of its further submission, opposing the submission of the Waikato Heritage Group to include the Claudelands substation on the corner of Grey and Claudelands Road, which is addressed as 732 Grey Street, as a Category B built heritage item in Schedule 8A. To be clear, there are two buildings located on the site, known as the Claudelands substation. One is a single-level building and one is a two-level building. There's only the two-level building located on the northern boundary of the site, the substation building, which Waikato Heritage Group seeks to include in Schedule A. That's our understanding. I rely on Ms Cadigan's expert heritage evidence that the substation building meets the threshold for inclusion in Schedule 8A, including her recommendation of the mapped extent of place. Before addressing the central issue raised in Ms Brown's evidence relating to the designation of the substation site, I note that WOW Networks has not provided any expert heritage evidence to support its further submission. I further note that Mr. Richard Knott, HSE's expert on historic heritage areas, recommends that a new Claudelands commercial HHA be included in the district plan in response to the submission number 307. The Claudelands substation site is included in that HHA and is specifically identified in the description of buildings and streetscape elements in the HHA statement. WOW Networks has not made a submission or filed evidence in relation to the Claudelands commercial HHA. I note also that Ms Brown has referred to section 193A of the RMA in her evidence, which relates to the seeking of a heritage order. I consider that this section has no application to this process, as this is a built heritage listing, not a heritage order. Ms Brown correctly identifies that the Claudelands substation is subject to an existing designation in the operative district plan, which is listed as K74, an electricity substation. WOW Networks is the requiring authority. Ms Brown states that as the substation is subject to a designation, WOW Networks is able to do anything in that is in accordance with our designation. As WOW Network proposes to demolish the two-level building, Ms Brown considers that its inclusion in Schedule 8A would be redundant. I have reviewed the notice of requirement for the designation and the conditions which are appended to my evidence in attachments A and B. Notably, the heritage values of the substation building were not identified at the time the designation was sought, nor when it was included in the district plan. I do not consider that the designation precludes the scheduling of the substation building under PC9 for the reasons that follow. Ms Brown refers to various Part 2 matters that she considers to be relevant, including Section 7B, the efficient use and development of natural and physical resources, and Section 7BA, the efficiency of the end use of energy. I agree that those are matters which the panel are required to have particular regard. However, Ms Brown has not referred to Section 6F, which requires the panel to recognise and provide for the protection of historic heritage from inappropriate subdivision, use and development as a matter of national importance. By not listing the substation building in Schedule 8A, which has been assessed by two heritage experts as having met the significant threshold for scheduling, HCC would fail to achieve Section 6F. However, if the building is scheduled, it does not follow that there will be a failure with respect to the Section 7 matters identified by Ms Brown, nor that it will prevent or hinder the ability of WOW to carry out the work for which the site is designated. As explained below, it is possible to achieve both the Section 6F requirement through the scheduling of the substation building while still meeting the Section 7 requirements and allowing WOW to continue to operate electricity substation from the site and develop the site as it intends. Under Section 176 of the RMA, Section 9.3, which relevantly provides that land may not be used in a manner that contravenes a district plan rule, does not apply to the public work under the designation, and that the provisions of a district plan or proposed plan apply in relation to the designated land only to the extent that the land is used for the purpose other than a designated purpose. The effect of Section 176 in this case would be that, if included in Schedule 8A, WOW Networks would not be required to obtain resource consent to carry out works on the substation building, including demolition, However, the designation is one which will require an outline plan to be submitted to HSC under 176A before any construction works occur on the site. That process allows HSC to request changes to the outline plan before any works commence. The matters of the outline plan must include are set out in section 176A3 A to F. Of particular relevance is F, that any other matters to avoid, remedy or mitigate any adverse effects on the environment. In my view, under the other matters to avoid, remedy or mitigate any adverse effects, Well Networks would be required to show how the outline plan addresses the adverse effects of any proposed works on the heritage values of the substation. For the reasons set out above, I disagree with Ms Brown that the scheduling of the substation would be redundant because the designation that applies to the site and WELL's future development aspirations. HCC has a positive obligation to protect the heritage values identified. As outlined above, I consider that the obligation can be met if the substation building is included in Schedule 8A, and that doing so will not hinder the designation works or offend the relevant Part 2 matters. Accordingly, I recommend that the substation be included in Schedule 8A while recognising the designation by including a hash symbol which will link to the following note 5 within Schedule 8A, which identifies the designation. Moving on to Mr Ray and Mrs Wendy Pickett, 13 Hammond Street. Mr Ray and Wendy Pickett, the landowners of 13 Hammond Street, have submitted an opposition to the proposed scheduling of the dwelling at their property. The Picketts have provided a lease statement which discusses heritage evidence provided by Mr Adam Wild and 2 desktop technical assessments appended to their statement. Ms Cadigan addresses Mr Wild's evidence in her evidence. I rely on her expert conclusion that the dwelling has high significance and support its inclusion in Schedule 8A. We have undertaken an internal review of the technical assessments within the HCC building unit. Appended to my evidence as Attachment C is a memorandum from Mr Alistair Arcus, HCC's Principal Building Advisor, which confirms that the reports are desktop and are not sufficient to verify the full extent of any actual geotechnical or structural issues. On that basis, I consider that the reports have limited value in determining the true extent of the works and the cost associated with those works. Mr Pickett raises a concern about the costs associated with the listing an item in Schedule 8A. He refers to HCC's Heritage Fund, which I note is no longer available. I also note HCC generally does not provide heritage rebates or waivers of resource consent fees for heritage-related applications. The issue of costs to landowners is not unique to 13 Hammond Street. I recognise that there are potential costs associated with identifying historic heritage in the district plan. However, there's also a public and private benefit in protecting historic heritage for the community. I note that the Section 42A report considers the costs issue and observes that the measures like the Heritage Fund, while beneficial for landowners of heritage items, create a burden on ratepayers. In any event, these measures are matters for the elected member decision-making, which sits outside this process. I agree with those comments. I consider the potential costs of scheduling 13 Hammond Street outweighed by the private and public benefit of preserving its historic heritage values for future generations. I support Ms Cadigan's recommendation that 13 Hammond Street be included in Schedule 8A of the district plan. That's the end in relation to build heritage. So whether you want to do questions or wait for the rest. Okay. Awesome.
Extensive, is it? Yeah.
I hope not.
No.
in respect of the HHAs, I am just going to refer back to my executive summary and my statement of evidence from the 3rd of July, from paragraph 9. On the 8th of February 2024, the hearing panel released decision number 2 of PC9, which removed the notified HHAs that HSC had confirmed and no longer pursued for scheduling in Schedule 8D. In addition to those HHAs identified in Decision 2, there are 4 further HHAs, Oxford Street West, Anglesey Street, Marama Street and Jamieson Street HHAs, which are not pursued. These HHAs were included in the notified version of PC9, but as confirmed in Mr Knott's primary evidence presented at Hearing 1, HSC no longer pursues them. However, they are omitted from the list of HHAs not being pursued in PC9 Decision 2. HCC continues to pursue the remaining 20 HHAs that were notified under PC9. On the 3rd of May this year, HCC circulated updated plan provisions in relation to the HHA topic. The feedback on the updated plan provisions was subsequently provided by Kāinga Ora and the Waikato Heritage Group. In response to their feedback, I proposed additional amendments to the plan provisions, which I've described in further detail in my evidence, and these are included as attachment 1 to this evidence. I believe they are included as attachment 1 to my built heritage evidence. I've made drafting improvements to each of the HHA statements to ensure a consistent template approach, and also edits in response to the memorandum filed by Jean Dorrell and David White. I've made additional minor amendments to the plan provisions to correct minor typographical and grammatical errors or to otherwise improve clarity. I have also amended the HHA statements to include clearer maps to correct minor typographical and grammatical errors, or again to improve the clarity in referencing. HSC has not provided any further expert heritage evidence in relation to the HHA topic and relies on the evidence provided to date by Mr Knott, Mr Gu and Mr Miller. And then following through to my rebuttal evidence, paragraphs 24 and 25. Response to the submitted evidence on historic heritage areas. No expert planning evidence has been provided on behalf of any party in respect to the HHA topic for Hearing 3. Further expert heritage evidence has been provided on behalf of Kāinga Ora. HCC has not filed any further expert heritage evidence and relies on the evidence filed in relation to this topic, which I have set out in my statement dated 3rd of July, which I've just been through. I briefly comment below on the lay statement provided by the Frankton East Residents Group, or FERG, below. Christina McCallum has provided a statement on behalf of FERG supporting the Frankton East HHA. FERG seeks the amendments to the Frankton East HHA statement. Having conferred with Mr Knott regarding their request, I'm comfortable with the specific drafting amendments that they have proposed. This concludes.
Yes, thank you, Ms Gold. I've got a number of questions on the planning provisions.
Yeah.
And the first of those, if I could take you to your statement on historic heritage areas at when you're responding to the matters raised by Kāinga Ora, starting at paragraph 25. So we're at 25, and just go down to 25D. Issue 4, you say, I support Kaingora's proposed new criterion in paragraph 10. Paragraph 10, they talk about like the benefits of developing in HHAs. I couldn't find in attachment 1 where you actually recorded that. You say I've included that in attachment 1.
Sorry, I'm just trying to track my.
Yes, I wouldn't necessarily have expected you to, record that word for word what was in their memo. But
No,
I
no,
couldn't find the essence of it.
I just confirm. The attachment 1, I believe.
Yes, it'll be somewhere in the criterion, won't it?
Yes, so the attachment 1 will be attachment 1 to my built heritage evidence. We just included it once rather than repeating it attached to the HHA statement of evidence.
Right. So, but
So
it'll
my
be
supplementary.
somewhere in here.
Yes, so E8 through to 13, as to exactly what I agreed with. I need to go back through my notes. Yeah, so my supplementary statement of evidence from 3rd of July has all the provisions appended, including the HHA provisions.
Yes. But that, I've got the criterion here,
Yeah,
which is what Kaingora was commenting on. And I couldn't pick out anything that was responding specifically to the matters raised in issue 4. What the Kaingora memo said was they thought that one of the criterion should give consideration to the reasons for the proposal, the benefits that will be generated by the proposal, any constraints on the efficient and safe use of the site that arise from the HHA, the extent to which the proposal will increase the ability to retain the building in use, and any relevant issues relating to health and safety of the public. And whether or not we agree that that's all necessary, I've made my mind up, but you indicated in your evidence that you supported that and it's been included.
yeah, and I believe that's included under E9.
E9. Okay, so it's E9 and I guess some of the wording in A and B there?
Yes, A and B.
Right, okay. All right, well, I'll have a further look at that, thank you. While we're actually in the document, my next question relates to some of the queries and questions raised in the Waikato Heritage Group memo.
Yep.
So if we could go to the objectives and policies at 19.2. One of their comments was on the wording of 19.2.4b and the use of the word enable there. And I wonder whether, my question is whether enabling is actually necessary. That policy in responding to the single objective, which is heritage values of an HHA are protected. That policy, I guess you've got to read hand in hand with the next one down, which is about development within an HHA. But it's really a question on your choice of using enabling there. And I did go into other parts of the plan just to see sort of how the plan is structured in that regard. Enabling isn't used, for example, in Chapter 20 in relation to natural heritage. And we'd typically look elsewhere in the plan for enablement, like in the zoning provisions. That's what enables. This part of the plan is about heritage and its protection. So could you just comment on the choice of using the word there and its sort of positive, just the way it's structured, I guess? Well, it could, I mean,
Can
it
I
could be
suggest-
providing, it could be provide for example.
Well, I mean, just contemplate the alternative, which might be to remove the word enable and the two words where it after HHA. So the policy would read, the use, development, and adaptation of buildings and sites within HHAs will not result in, which is I would have thought meets the issue that's being discussed.
Yeah, no,
It's a
I take
directive.
your point in terms of the word enabled, and you're
Yeah.
probably, you are
I mean,
correct
I mean,
that we don't use it.
it's possible when you look within that the total clause, whether there is some point of enabling adaptation of buildings, because sometimes buildings need to have adaptation enabled so that they have an ongoing productive use, which helps their preservation. And so I was sort of wondering whether it was heading down that track as well.
Yeah.
But it covers the whole gambit, doesn't it? It's enable the use, development and adaptation. So that's just one point. I won't labour the point anymore.
No, that's fine. And just looking back at where the wording for these objectives and policies has come from, it was what was put forward by the 42A author previously. So I have purposely not delved any further into these. I've tried to stay away because we were comfortable with that position, but I do take your point about enabling. And look back to 1923, I believe it's H now, for the built heritage, and we've got a similar vein. What you're saying is the continued use or adaptive reuse of a building. And I think that's what that's getting at. We don't want to say you can't use these if you haven't got a. So yeah.
Right. Thank you. So just staying on that page. And the next one down, 19.2.4.C. Sorry, 4C. The share power of that clause talks about development within a HHA protects the heritage significance. And again, I was thinking about the choice of the word. Is it the significance or is it the values that contribute to that significance? And I guess you've got to read the whole thing together, because whilst the beginning talks about heritage significance, the way you achieve that is by Roman 1 and Roman 2, which then talks about, well, the first one talks about the values. So it's a question is whether significance is the right term, or whether it's perhaps it should be values.
Or ranking. Or ranking.
Or ranking. Yes, it's whether you're ensuring Roman 1 and Roman 2 to support the ranking.
The other term,
Potentially.
Yeah, the other term again we've used with the built heritage is qualities. So referring back to those to the assessment criteria, so that potentially just an oversight using significance is not quite right in that context. So whether qualities or values is more appropriate.
Right. In Roman 1, we've got the form, scale and proportion of the development. I just wonder whether that was meant to be proportions of the development. So Roman 1 talks about form, scale and proportion, so it's actually talking about the built development. Roman 2 talks about the location of the development, so we're covering all things there. So going back to Roman 1, the form, scale and proportions of a development,
Yep.
whether the S on the end of that is actually what was meant, as opposed to proportion.
Yeah, again, yes.
And looking at Roman 2, the location of development does not detract from the relationship that exists with other buildings and sites in the HHA or with the street. My question is whether does not detract is perhaps too low a bar, and whether we should be looking at more something like maintains or is consistent with the values described in the HHA statement. So the interpretation of this would derive from what was in the HHA statement for each of the listed items. And so when I go to that, I would expect to get guidance about the location of the development. And when I look at those HHA statements, and they've been tidied up, someone spent a lot of time on them, I appreciate that, and they are now in a very consistent form, such that after reading the general introduction of what the HHA is about, it then gets down to a clause that says this is what you've got to do in a resource consent scenario to make sure that you maintain those values. So it's actually about maintaining the values, whereas this policy just talks about does not detract from, and I just wonder whether that's too low a bar.
Again, I haven't delved too much into these objectives and policies. They were what was put forward in the previous hearings, but again, I've made a note and we'll look to that point.
Right. Okay. So in a nutshell on that one, it's whether this statement is consistent with what we find in each of the HHAs, which have been very specifically worded in that way.
Yes, so yeah, the flip side is we need to come back and just cast our eye over this and make sure we're aligned up.
Right. Thank you. Down to 19.4.2, where you've done some significant work on new fences and walls to address some issues raised.
Yes.
I'm just looking at C. So C currently says where the HHA statement does not typically have fences or walls, and this is identified as a feature of the area in the HHA statement, the open front boundary treatment is retained. I thought perhaps that could be shortened up, just simply to read, where an HHA does not typically have fences or walls, an open front boundary treatment is retained. I mean, that's just basically what we would like to see there. I'm not changing the meaning of it, it's just simply a wording thing. So my proposed words were, where an HHA does not typically have fences or walls, comma, an open front boundary treatment is retained.
No, I've noted that. At first glance, I think that would probably tidy it up. It is very wordy.
The next one was actually down in the activity tables. Oh no, sorry. 19.6. Matters of discretion and assessment criteria. At criteria, it's now 2, about alterations and additions.
Are we historic heritage
So,
areas
yeah.
or built heritage?
So 19.6
Yep.
in the table on what is now the second item, alterations and additions, bracket excluding maintenance and repair.
Yes.
I think this is worded slightly different to another place in the plan. The final pink words, or to the interior of any structure or building listed in Schedule 8A, I think should read and interior, bracket, if the interior is listed in Schedule 8A, because you've gone to, there are specific items in 8A that have the interior listed. I don't think there's that many, but there are some.
There's currently one.
One?
Yes.
Okay. Right, so I think it's meant to read alterations or additions, excluding maintenance and repair, to the exterior of any structure or building ranked A asterisk, ranked B, and interior, bracket, if the interior is listed in Schedule 8A. They're the words that have been used elsewhere. Yes.
Yeah, again, thank you for noting that.
Right.
That just hadn't flowed through.
Okay. And final couple of matters down in the actual criteria in E8 through to E13 in section 1.3. So historic heritage areas under E8. Just in that first one there, I think on that first line it should be E8 to E13 because you've added a extra one. You may have got that already.
I may well have fixed that electronically, but not the printed version.
And you did some work on making these read better by the insertion of some words, typically taking into account.
Mm-hmm.
I think those words need to go into E12 as well. So at the end of the header clause on E12, taking into account just helps A to E read better.
Yep.
All right. That's all from me, thank you.
I should just signal there will be quite a few wording changes coming through subsequently, and I'm not going to go through those now, but I think we'll have a we'll have a discourse, obviously, once we get to a point where we've got agreement on general directions on that. So unless you really want the detail gone through now, Mr Muldowney.
No, no, sir, I'm just thinking about what's the most practical
Yeah,
way
yeah,
to deal with it. It
yeah.
may be, as part of the wrap-up, we have a discussion about how to produce
Yeah,
a final version that captures the signals, because there's no point in leaving it for a decision. We might as well
No.
attempt to capture the signals from the panel
Yeah.
in an updated draft, so we can
Yeah.
perhaps just deal with that at the end.
absolutely. And I mean, in the normal course of events, I would imagine that we'll probably have a workshop of some sort to go through the text and make sure that we're not crossing over stuff we're getting out of scope. Yeah. Vicky?
There was just that point that was raised, I think, earlier around the well site and the designation. Now, I think the chair asked the question, and I think you've responded to it in your, might have been your para 18, that it is a permitted activity to demolish. Is that correct? In that zone?
In terms of the underlying
Underlying zoning,
yes, it
yes.
would be permitted. It's, I believe, a business zone 6 is the underlying zoning under the ODP. It's through PC9 that it's been picked up as heritage, a specific heritage item, and as a HHA through the hearing process, so that wasn't even notified. So currently it's the underlying business zoning.
Okay. And just, and I think you took us through that they would still need to fill in an outline plan if they were planning to demolish the building. And council has the ability to provide comments on that. Now, if council's comments aren't accepted, then council does have an ability to challenge that in the Environment Court, don't they? So there is I guess it has some teeth, is what
Yes,
I'm
yes,
thinking.
it's
Yeah.
council's only ability is to Environment Court
Yeah.
to challenge that.
Thank you. I think that was the main one from me. Thank you. Yeah.
Yeah, Mrs. Gold, thank you. I wonder if I could first lead you to having a look at Alistair Arkist's, the Principal Building Advisor's memo to Council dated the 6th of August 2024. This is in reference to Hammond Street. My first question is, you've relied upon this memo in your rebuttal evidence to assert that the reports provided by the Picketts from a geotech and an engineering perspective are simply desktops, and I summarise this is not verbatim, and should hold less value, hold very little value. I think that's your assertion in your rebuttal.
Yeah, those are geotech and the structural reports are very much a desktop, and they're an initial point, and I think they go into it in those reports that there is a number of statements in there, in those reports, that this is what they are, and there is further work that needs to be done. They shouldn't be relied on in totality at this stage.
So relied on totality is slightly different to, I think, the way you've worded it. And I just I'd like your comment in regards to the final sentence that Mr. Arkis has that says that his own analysis, that this is not a full and final assessment of the report supplied. So his own analysis, I'm suggesting to you, is simply a desktop activity.
Yes,
Would you
I
agree? Would you
yes,
agree with
he's
that?
in-
So can I now take you back to your rebuttal evidence, where, as I've summarised, you assert that because it's desktop, it should hold no value. I'm reminded by Mr. Maldani's legal submission that, in fact, cost and a cost-benefit analysis could creep into the equation in regards to whether or not the panel, when weighing this up, I'm just trying to get your opinion on whether or not council has or should have taken a slightly deeper look as to the potential cost ramifications leading from the 2 desktop reports that's been added to the evidence of Mr. Pickett.
So what was your question exactly?
So my question is, are you not dismissing the value of the reports based on a desktop analysis of Hamilton staff that themselves were desktop? So I'm just trying to understand what weight I should give Mr. Arkist's report in light of the fact that his own report is a quick desktop analysis. And your assertion is that we should place no weight on the reports from the geotech or the engineer because they're desktop. I'm just trying to ask, what weight should I place on Mr. Arkist's report?
In terms of what costs would eventuate because of those reports,
Well, as to the assertion that the geotech engineer, the engineer in the geotech has said that there are some potential structural issues, I'm just feeling, I'm trying to understand what weight I should place on your assertion that this is a desktop activity and should hold no weight, because that's what you're asserting in your rebuttal. I think you used the words, let me go back and find
yeah.
the exact words you
Yeah,
used.
so I've said that it plays,
Little, is
yeah.
it?
The reports have limited value,
Limited value.
yeah, in determining the true extent of the works and the costs associated with those works. So at this point in time, we don't know what that true extent of those costs, and should that come to light through the hearing, we may have to come back to this point. But as it stands, these have, to use my words, limited value in determining that outcome at this stage.
Okay, thank you. That's very helpful.
Can I just ask you the hypothetical question then? If in actual fact there was a report or 2 reports that came through and they reached the same conclusion effectively, that the order of restitution would be in the order of 200,000 or whatever the number was, what difference would that make to your assessment and your recommendation to us if that were the case, assuming that those reports substantiated the claim? Would it make any difference?
I'd need to turn my mind to what an ordinary person would need to be doing to the house full stop to maintain it versus.
I guess my question is trying to get to the point of at what point do those matters become tipping points in terms of decision to list or not list? I'm trying to get some sort of sense as to where that boundary might be, or what the parameters for consideration might be at that point.
I'd need to have further thought on that point as to, what is the tipping point?
Okay,
Not
all
too
right. I mean, I accept that's a hypothetical question. That's fine. But a lot of these things are on fine balances in terms of judgment calls that are going to be made. And I guess in terms of when we get to subsequently considering the conditions and the provisions, there may be some issues there that we just want to hedge a little bit or not. So it's probably going to be relevant in terms of final provisions. So if you've got any thoughts on that, that would be helpful to have.
Can I just pick up that
Yes.
point with you, sir? So, because we did discuss this in my opening, I mean, there is, I think, a place for this in the Section 32 analysis. And that was in the context of list or not list. You know, so at what point does, for example, you talk about a tipping point. And I think there's a couple of things going on. So there's a number of layers to this. The first is any property requires maintenance and dollars spent on it to maintain it, whether it's heritage listed or not. And those inherent costs need to be ignored in my submission. And so you're dealing with the marginal costs between those inherent costs and the heritage-related costs. Those are the relevant costs. The question is then, where does that marginal cost sit in the overall Section 32 evaluation, given that it is borne by private landowners? There is no heritage fund. There is a public and a private good here, but there is no heritage fund allocated to this, so it sits with the private owner. Is there a tipping point at which point the cost to the private owner is so great that it should count against recognising the heritage values of the site? Or, as you say, is it better addressed in the provisions? So you list it because heritage is heritage, and then you somehow make some allowance for it in either it's the assessment criteria, where you start to look at costs and you start to evaluate costs in terms of the protection of heritage, and you can start to make judgments to say it's not appropriate and fair to place this burden on the private owner to spend, you know, these extra hundreds of thousands of dollars to achieve this heritage protection. And so I'm going to condition a resource consent which somehow ameliorates these costs. And it may be that that's the better place for this issue to sit rather than list or not list.
Certainly, I mean, that's what I'm thinking. I'm thinking there needs to be some direction for that consideration and where it sits. Yeah, I think
So we'll have a look and see what's happening in the assessment criteria, because it may be, I mean, I think at this stage, cost of repair and so on is not squarely dealt with in assessment criteria. So we could have a look at that and see if there's some potential solutions that we can come up with in terms of the drafting.
I'm not sure whether this is for you, Ms. Galt, or for Mr. Muldowney, but in the HHA statements themselves, quite often under cultural qualities assessment, there's no reference to previous Māori use. And I guess my question is that something that's likely to be looked into further through that separate cultural plan change, and they're going to be updated? Is that the sort of the plan at that point?
Well, yes, one would hope so, but also one would hope that if there are significant cultural histories associated with the HHAs already, they should have really come through in the assessments that have been undertaken to date and the descriptions to date. So
quite often they'll say not assessed, or they simply don't mention any Māori usage previously. And I guess I'm just thinking, you know, at the beginning, the cultural issues were carved off, and so we're looking purely from a Pākehā settlement sort of aspect, and we don't have that information, so I'm just wondering where does that get added back into the process? Yeah, and I guess, and I think I've raised it in maybe the last hearing about the use of the word pioneer as the Hamilton Pioneer Development Period, and I think we had a discussion where I think Mr. Knott might have said it was a term of art, but I had sort of said, you know, that implies that there were no people here before, you know, Pākehā came and settled in Hamilton, and whether or not some thought had been given to the use of a different term such as early Pākehā settlement, early Pākehā development period rather than pioneer. So I'm not sure whether any thought has been given to that, but would appreciate a response
Come back to that.
on that. And then just finally, where are things at with that additional work stream with that cultural plan change? I think in one of our decisions we indicated we were encouraging the council to prioritise that. So I just wonder where it's at in terms of timing.
Yes, and as I say, I don't have the answer to that. I'll check that with Dr. Davey and let you know where we're at on that point. I know there's a lot going on in the planning policy team, and exactly where that sits, I'm not sure.
I've just got two residual matters that I don't actually recall what happened. Two submitters, Kaute Pacific Trust, sought the exclusion of 220 Commerce Street from the Frankton Commerce HHA. Where are we at on that one? I can't recall where we're at on that one or what happened with that. That might be something that you come back to us on. And the second one in the same context, of course, was the Waikato Contact Bridge Club, which in 56 Brookfield, who were looking for exclusion from the Hamilton East HHA. And again, I'm not quite sure where that landed in terms of council's view on that. So if you could just refresh us on that, appreciate that.
Thank you.
And I think that's probably lunchtime. And a bit, isn't it? Just
Well,
so,
thank you. That completes the primary evidence on those two topics for city. So yes, that's the in terms of the schedule. That's it from the city until we hear some responses at the end. So I think we move on to Waikato Heritage Group after lunch.
yes. Where's Mr. Callaway gone? Oh yes, right. I'm suggesting that we maybe take lunch till 1:15. Does that suit you? That's okay. All right. Let's resume at 1:15 in that case, or thereabouts. Thank you.